Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 23-1046, Citizens Action Coalition of Indiana, Inc. Petitioner versus Federal Energy Regulatory Commission. Ms. Datla for the petitioner, Ms. Chu for the respondent, Mr. Marotta for the intervener.
Good morning, counsel. Whenever you're ready.
Good morning, Your Honors, and may it please the court. I'm Kirti Datla, representing Citizens Action Coalition of Indiana. FERC's certificate order authorizing the Henderson County expansion project rested on 3 errors. First, FERC stated that the project would cause the retirement of a coal plant and therefore reduce downstream greenhouse gas emissions without confronting the contrary conclusion in the very document that it relied on, the record evidence, and CAC's arguments, which show that no such causal connection exists. Second, FERC didn't assess the significance of those emissions as NEPA requires, or respond to the argument that it needed to consider them as part of its Section 7 determination under the Natural Gas Act. And third, FERC defined the purpose and need of this project so narrowly as to preclude consideration of reasonable non-gas alternatives, which affected its analysis under NEPA and the Natural Gas Act. I'd like to start today with the retirement issue this morning, because I think this is a straightforward claim that might avoid the need to address other issues in the case.
Straightforward factual claim, right? So you need to show no substantial evidence.
I'm sorry, Your Honor, I'm a little hard of hearing, if you could.
I'm sorry. Doesn't seem to be projecting too well. It's a factual claim, right?
Our argument is that it's an arbitrary determination, and there's a component of that there's a failure to respond to contrary evidence in the record and contrary arguments in the record. But I think even if you accept Texas Gas's characterization as a substantial evidence challenge, there's just no evidence in the record supporting it. But we would frame it as a classic arbitrary and capricious claim. I think the arbitrary nature of FERC's statement can be summed up in 3 sentences. At JA 266, FERC states that the final EIS explains that the project will result in a net reduction of downstream greenhouse gas emissions due to CenterPoint's retirement of coal-fired generation at the AB power plant. Second, the very page on which the order cites for that proposition states that the table presenting those emission estimates is not used to determine project impacts or to establish a baseline for comparison with proposed project emissions. And third, FERC provides no explanation in the order for how it reached a conclusion that's contrary to the very document on which it relies, and provides no response to CAC's arguments as to why that conclusion is untenable in light of the record. The court should send this issue back to FERC to either provide an explanation or to correct its statement about the causal connection and the nature of the downstream greenhouse gas emissions in this case.
Ms. Dowell, if I can ask you about your argument about FERC's purpose here, which appellants say is overly narrow, and but in your briefing, there was a concession that FERC can't order the Indiana state utility to make a different choice, right? Indiana has chosen to build a gas-fired plant, and then we'll need a pipeline to bring natural gas to its plant. And your submission is not that FERC can make any different choice. So if that's the case, then how is the purpose defined too narrowly?
So we think the purpose is defined so narrowly in this case for, I think it can be seen at JA 145, for example, where the purpose and need of the statement is to provide up to 223 decatherms of natural gas to these specific power plants. So it's basically the project proposal. But I take your question to be asking, why did FERC need to consider other alternatives given that Indiana had decided that it has a preference for natural gas? And I think the response is that in any situation where a pipeline is connected to an end use, there are going to be 2 relevant actors in this situation. There's going to be the regulator of the pipeline, which is FERC, and there's going to be the regulator of the end use, which in this case was the Indiana Commission. But neither of those determinations on either side of that bind the other person. And I think, one clear way
Well, they're
to,
not binding, but FERC can't require Indiana to choose a different method of, providing power to its citizens.
right. I think what FERC can do is say under its authority, under the Natural Gas Act, it has an obligation to consider and to determine that this pipeline is required in the interest of public convenience necessity. And if there is a reasonable alternative on the table, then it has to weigh that alternative as against the pipeline proposal. And I don't take FERC to have said, in light of Indiana's decision, that the status quo has changed so much that it's impossible for any other alternative to come about if we deny this pipeline. What it said is that we're blinding ourselves. We're walling off any consideration of whether there is a non-natural gas alternative on the table because of Indiana's decision.
What's the alternative? What's the reasonable alternative they've excluded?
Yes.
Something other than natural gas.
So we think the set of reasonable alternatives comes from one of the proper purpose and needs that FERC could have relied on, which is actually.
I mean, do nothing?
No, not at all. So
Okay.
we take the purpose, the sort of legally sufficient purpose and need of this project to provide reliability when intermittent resources are down. And as we explained in the rehearing petition and put evidence into the record, that sort of backup reliability power can be provided through many mechanisms such as battery storage, demand response reduction, buying electricity off the grid, which is exactly what is happening right now that there is no natural gas plant online and the coal plant has been shut down and the mix of electricity generation has shifted.
But then you're using FERC's authority over transportation to second guess Indiana's judgment with respect to generation.
Yeah, so I would say two things.
Which I would think you would embrace. They're shutting down coal plants. They're replacing them with renewables. And they want a natural gas backup so people can turn the lights on cloudy days.
Yeah, so I think I would say maybe three things in response. So first, I don't think we would consider this to be second guessing. I think this would be FERC making an independent judgment that the requirements of the Natural Gas Act have been met. And second, I would say, I don't think this is a controversial proposition. So the transcontinental pipeline case that's cited in the briefing from 1961, Supreme Court case, said that FERC's predecessor agency, the Federal Power Commission, could consider end uses when making its determination under the same statutory language here. There, FERC denied a pipeline because it said the natural gas is going to industrial boilers. And in that case, the Federal Power Commission said that coal would be a better use. And that was its reason for denying the pipeline. And so, obviously we recognize that there's, two different actors here and everyone should be respectful of everyone else, but I don't think this is controversial. And the third thing I'll say is that I think there are really important reasons why FERC has to make that independent determination of whether the pipeline is required. Part of that is because FERC is also protecting other states' interests. So the pipeline here crosses through Kentucky and has effects on that state that aren't accounted for in Indiana's process. You can imagine much bigger, much more impactful pipelines that cross many, many states. And FERC's obligation is to take those interests into account. And of course, FERC is also protecting important federal interests in this case, the interests that the public convenience and necessity standard protects, like those of landowners whose property might be taken because of eminent domain, those of consumers who might face higher ratepayers, and of course, the environmental impacts.
Can I ask you about the social cost of carbon argument? Imagine I've never heard that phrase. Imagine I don't know how it works. What is it? Social cost of carbon tool. Social cost of greenhouse gases tool.
Yeah, it's an attempt to monetize the impacts of greenhouse gas emissions. But if I could, I just want to make clear that our argument here isn't akin to the ones that this court has seen in prior cases, which is that we're not arguing that FERC was required to use the social cost of carbon to make a significance determination in this case. Our argument is that this court has said in Sable Trail that FERC has to make a significance determination. That's what the NEPA regulations say. That's what FERC's own regulations say. And the order here says we're declining to make a significance determination. And
But I
that's
think
what we're challenging
If
here.
I could be misremembering, but I think that the rehearing petition specifically mentions social cost of carbon tool.
Yeah, so the argument in the rehearing petition is that FERC has to make a significant determination. It has a whole range of options on the table to do so. One of those we mentioned is the social cost of carbon. Others include comparing the emissions from this project to the emissions reduction goals of the nation or the states. Of course, here there aren't those emission goals. They also include
So
just making a, I'm sorry.
you can finish the sentence.
Yeah, they also include just making the same kind of qualitative judgment that FERC makes for other environmental impacts that don't have clear bright line rules. So in this very order, FERC discusses, for example, the impact on wetlands and forested lands. There's no bright line rule for significance. It just requires the agency to make a judgment, and it'll get, some deference on the back end of making that judgment.
I think if I also remember correctly, at least one of the orders or statements in the case, the commissioner said, even if we did social cost of carbon here, it would be, and we would reach an insignificance finding. Am I remembering that?
Yeah,
right?
so I think this is in
Maybe
Texas
Commissioner Glick,
Gas's,
but
I'm sorry.
No, am I remembering that right?
Uh,
I know you may disagree with it. I'm just asking as a factual matter.
Yeah, I think Texas Gas makes the argument that the two of the commissioners wrote statements on the denial of rehearing that said, we disagree.
Well, they're
on
the ones
natural
who
gas.
don't want to ever do social. They're the ones who don't want to ever do social cost of carbon, I think. But I think
That's right.
one of the
One of them is no longer a commissioner, but yes, those two are, yes.
But I think one of the commissioners who does want to do social cost of carbon said in this case, we should just do it because it's going to lead to an insignificance finding here. So why not just say it's insignificant? But again, I might be misremembering.
Yeah, so I'll say two things on this. One is that
Before you say whether you agree with it, am I remembering correctly?
Yes.
Okay.
Sorry, I should have said that. So I agree that the concurrence to FERC's order by two commissioners states this project will reduce emissions, and so we should have said it's not significant. This is dependent on the argument that I started with, which is that the project absolutely does not reduce emissions. But the second thing I'll say, which is maybe a broader point, is that I think the standard order of operations when we think the agency hasn't explained itself, and that's obviously in a concurrence and not FERC's order, is to send it back to the agency to allow it to do so.
Fair.
And
I got that. So if I guess I'm wondering, I think there may be some common ground here between me and you. I think if you did social cost of carbon, and you did it and you excluded the closing of the coal plants, I think then you may well be looking, maybe you'd be looking at a significance finding, a finding of significance.
I guess what I would say, and I really want to find common ground here, so I hate to not do that, but I think it's hard to find a finding of significance when the order disclaims that that's what it's doing. And I suspect that the reason the order...
I guess I'm talking about a different order. No,
Okay.
the order as you would have them do it.
Sure.
And because if the social cost of carbon of this project is, as the order I think says, between $1 billion and $12 billion, then it seems like that's significant, and which I think maybe you would embrace. But then it's leading to where I'm going with this, which is this is a relatively small project compared to some FERC certificates, and if the cost of this is as much as $12 billion, then when is the benefit of a project ever going to outweigh the carbon costs?
So I think I'll say two things. So first, I think you seem to, the question seems to present the issue as a straight up cost benefit analysis. And I just am not here to take a position on whether that's accurate or not, because it's not a argument we raised in our brief. But I think what I'll say is, at least on the NEPA side of things, it's a procedural statute, and it requires you to say why you think that the ultimate benefits of the action are worth the environmental costs. Maybe there's no way to stop them. The project is so important, whatever the answer is, it's a procedural statute that doesn't impose substantive requirements. And I think on the Natural Gas Act side of things, it would be like any other agency determination, where as long as it provides good reasons that are, not arbitrary, then it's going to get deference on the back end of that determination.
But can you imagine a natural gas project with benefits that will outweigh the social costs of carbon?
I'm sure I could imagine one, because I don't know. I think this goes back to my first point, which is that I don't know that the way to think about this in the end is as a straight up monetization of all costs on one side and all benefits on the other.
A pretty good candidate for one would be a 25-mile pipeline designed to facilitate conversion to non-renewable to renewable fuel generation.
I think if the question is posing, if we sent this back to FERC and asked them to make a determination and they decided this is both, valid under NEPA and under the Natural Gas Act, I think, as I said before, we think they would get some deference for that under standard administrative law procedures. The problem here is that FERC declined to make a significance determination despite the clear regulations in this court's precedent saying that they have to do so.
I think you did oppose the certificate, right? I mean, even before FERC had.
I'm sorry, did we oppose?
Like, you opposed the issuance of a certificate here, right?
Yeah, we did oppose the issuance of, yes.
And maybe I think I'm hearing you correctly. And I think what you're saying is that the argument about social cost of carbon is linked to a significance determination, not to any other requirement.
Yeah, for NEPA purposes.
Is that correct, what I just said?
Well, I would just put it slightly more broadly,
Okay.
which is that for NEPA purposes, our position is whatever method is chosen to use to assess significance, social cost of carbon is one on the table. As I mentioned, we made arguments as to why there are other alternatives on the table. That has to lead to a significance determination at the end of the road. And part of that is, not just because this court has said so, but because it triggers obligations to consider things like whether those significant impacts can be mitigated.
But let's say in a perfect world, FERC did social cost of carbon, said we're not only going to put it in the order, but we're going to actually consider it as part of our decision making. And we have considered it, and we consider this to be an environmentally significant action. Is your point that going forward after that, the rest of FERC's analysis can ignore the social cost of carbon?
No, that's the first argument in our opening brief, which is that we argued that FERC has to explain whether and how it is weighing any greenhouse gas emissions in its Section 7 determination. And I also think that's the premise of Sable Trail, which is that the reason it matters for NEPA purposes is because it matters for Natural Gas Act purposes.
I'm wondering if you could say a little bit more about the relationship between what has to happen under NEPA and what is required for a Section 7 analysis, because you've acknowledged, as our cases do, that NEPA is a purely procedural statute. And so, but it does seem that much of your briefing and your argument here suggests that what happens in the NEPA analysis is essentially connected to how FERC makes its public convenience and necessity argument.
Right. So
I'm just wondering how you see that interrelationship.
Sure. So the entire purpose of NEPA is to inform the agency's ultimate decision. And here, the ultimate decision is under Section 7 to make the determination that the pipeline is required in the public convenience and necessity. So there are kind of two basic NEPA issues here. So one is the consideration of alternatives. And as we've been discussing, the failure to consider a reasonable alternative means that the Natural Gas Act determination about whether something is required is sort of necessarily also questionable, because it's hard to say that something is required if you don't know what the alternatives to that action might be. And then on the greenhouse gas emissions, both of the greenhouse gas emissions issues, I think, affect the natural gas analysis because we think FERC got the number wrong. And so any assessment that happened under Section 7, which it isn't clear from the order that any happened at all, but any assessment would have been based on an incorrect figure. And then again, the assessment of significance is relevant because it reflects a judgment from the agency about whether there really are adverse impacts that anyone should care about. And without that, it's hard to see how it weighed into the natural gas analysis.
Maybe, this is very similar to a question I already asked, and so you may think, well, I've already answered it, but I just, I'm not sure I totally understand the answer. What natural gas project would you not oppose?
Well, in this case, we're representing clients who live near this natural gas plant. And so probably the only natural gas projects that they would oppose are the ones that directly affect their daily lives.
Applying the legal arguments that you make in this case, what natural gas projects are legal?
Yeah, I think what I'll say is the only thing we could do we in the abstract sense of not my clients, but some other we could do is to say that there are these legal obligations that Congress has said the agency has to meet. And if they don't meet them, then it's subject to challenge. If they do meet them, that argument becomes much harder.
But applying the arguments you made in this case, when would FERC ever be able to meet them?
Yeah, I think what I've said is that I think there are projects that FERC could decide are meaningful. I have not thought through all of the, I haven't thought through all of the potential pipeline projects in this country. I just don't have an answer for you on that one.
Okay, I appreciate that.
Thank you. We'll give you some rebuttal. Ms. Chu, good morning.
Good morning. May it please the court, Susanna Chu representing the Federal Energy Regulatory Commission. Let me start with the first issue that was raised, the retirement of the coal plant and the causation issue. Whether that is framed as a substantial evidence factual issue or an arbitrary and capricious argument, the agency was not unreasonable in taking into account that the purpose for this pipeline is to supply natural gas to a power plant in Indiana that is going to supply backup generation for a new portfolio of renewable power sources. So the commission did take that into account because that's the whole purpose of this pipeline. And it calculated net emissions resulting downstream from the conversion of this plant from coal to natural gas. And also the fact that this plant is not running, it's running like 2 to 7% of the time. But the commission also did the full analysis. It did the analysis of the emissions from the pipeline itself. And that analysis is exactly the same analysis that the commission did in the Alabama municipal case, which came out last week, and the Center for Biological Diversity case from last year.
Sable Trail says you have to consider the downstream indirect effects. And one way to read the order is you did two potential analyses. You did one analysis where you just consider the pipeline. You don't consider any downstream effects. You did another analysis where you consider the pipeline and you consider the downstream indirect effects from the gas plant, but you also consider the closing of the coal plant. And why doesn't Sable Trail require you to do a third analysis, which is the pipeline and the downstream indirect effects of the gas plant without considering the benefits of closing the coal plant?
I think, Your Honor, I think that is an analysis that is in the environmental impact statement. I believe that the commission did a full analysis of all of the emissions relating to this project and the power plant at the downstream of the project. So I think the reasoning,
Can you give, I mean, I believe you, but it will help me when I go back, and the panel is working on an opinion, whichever way it goes, to be able to know the JA page that you're referring to there.
I would have to take a look at, there are multiple tables in the environmental impact statement. My understanding is the
You calculated the social cost of carbon for the downstream emissions from burning the gas, correct?
I think so, yes, that's right. The
And in
social
order-
cost of
and
carbon.
In order to monetize, to get the social cost of carbon, you need to know the volume of emissions from burning the gas, right?
That's right, Your Honor.
So I didn't
Yeah.
write down the page where you did the intermediate step, but I thought you actually went farther by monetizing,
Right, Your Honor. We actually did.
which Sable Trail does not require.
That's right, Your Honor. The commission here actually went farther than it did in prior cases. Although it did this analysis in both Alabama Municipal and in Center for Biological Diversity, where it calculated the actual emissions, and then you applied the social cost of carbon. It applied all the different discount rates and came up with a range of values.
Did it base its decision in part on the social cost of carbon?
No, Your Honor. I think the commission did not rely on the social cost of carbon. It did provide the numbers for informational purposes. The commission has continued to find that the social cost of carbon is not, it's an imperfect methodology for determining the impacts in project-specific cases like this one.
Is Sable Trail best read to say FERC has to not only note the downstream effects, but also base its decision in part on the downstream effects?
I think that's right. I think Sable Trail does say that the commission has to do the downstream analysis, which it did not do in that case. And it
Doing
has
the
done in
analysis.
every case since then.
Doing the analysis is a little bit different than basing your decision, at least in part, on the analysis.
Well, that's right.
Did you do both here?
Well, the commission did a full analysis that is consistent with Alabama Municipal and with Center for Biological Diversity. It has found that it is not able to make an up or down call on significance for climate change purposes. And, the commission has explained, it addresses the significance broadly of greenhouse gas emissions. The climate change section in the environmental impact statement discusses climate change impacts. The commission does the full analysis of all of the emissions relating to the pipeline and to the power plant. It even went to the stage of calculating potential social cost of carbon numbers. But the commission has said there isn't a threshold. I'm sorry.
How does all of that analysis affect whether something is in the public convenience and necessity
Well,
in FERC's reasoning?
So FERC relies on the 1999 certificate policy statement to determine whether a project is in the public convenience and necessity. This is explained in the certificate order around paragraph 19. But basically, it does an economic analysis first, and then it proceeds to do an environmental analysis. And that environmental analysis is the NEPA analysis. It is what we've been talking about. So that the whole NEPA analysis is necessarily part and parcel of the Natural Gas Act public convenience and necessity determination. That's why in our brief, we cite to Center for Biological Diversity and the Delaware Riverkeeper case, where the court has found that if the challenges under NEPA fail, then they necessarily fail under the Natural Gas Act as well, because that environmental analysis is necessarily part and parcel of the Natural Gas Act analysis. I'd just like to add that the commission here is a collegial body. It acts by majority vote. And, to the extent that any of the commissioners would have said, something else in addition to what was said in the majority order, that is a different issue. You know, in terms of the majority order, all of the commissioners here agreed that this project was in the public convenience and necessity.
And the reasoning is a bit of a fudge.
I don't think it's a bit of a fudge, Your Honor. I think I mean,
Bit of a fudge because people with very different perspectives all think this is an easy case. I mean, some commissioners want to throw out this whole social cost of carbon analysis to begin with, and others want to embrace it, but think this is the easiest case in the world because you're supporting a renewable generation facility.
well, I hear you, Your Honor. Actually, this is an easy case. And I think actually all the commissioners agreed it's an easy case. It just happens that perhaps some commissioners would have said something else, but it's an easy case. This
but if it's an-
pipeline is in the
if
public
it's an easy
convenience and
case,
necessity.
If it's an easy case, why wouldn't you have just responded to what the petitioners argued in their rehearing petition?
Well, the lack of a rehearing order, Your Honor, I think does not undermine any of the reasoning in the certificate order itself. There are times when the commission determines not to issue a rehearing order, and our position is that the certificate order stands,
What if the
you know, it's
rehearing
sufficient.
petition
And in addition
had-
to an environmental statement, those two support the commission's action here.
What if the petition for rehearing had made an outcome determinative argument that was undeniably persuasive? Would you have had to respond to it?
I think that if it were outcome determinative and it had not been raised previously, then yes, the commission would have had to respond, of course. But in this situation, there was no outcome determinative argument that was made. So I think the commission acted reasonably in deciding
They
to
think
rely
it's-
on a certificate order.
They think it's potentially outcome determined.
That's right, Your Honor. Petitioners do think so. But again, I would say Center for Biological Diversity and the Delaware Riverkeeper case and the commission's reasoning here all support the reasoning that the environmental analysis is part and parcel of the Natural Gas Act public convenience and necessity argument. There's not a separate standard. And, this argument falls on the same grounds as it falls on the NEPA statute.
Thanks for your patience.
Thank you, Ms. Chu.
Thank you.
Mr. Murata, good morning.
Good morning, Your Honor. May it please the court. Sean Murata on behalf of the intervener, Texas Gas. Let me just get you those JA numbers where the commission did exactly what Sable Trail requires, which is JA 206 and 207, where there's a table where the commission lays out the exact thing that Sable Trails requires. What are the emissions that are going to be created by this downstream power plant? They then also take into account the offsets that are created by the fact there is the retirement of the coal plants. And then they go on further at JA 218 and monetize that through the social cost of carbon. Now, admittedly, the commission in this case, like in Alabama Municipal and all of the other cases, says we're not really sure what to do with that because it's not clear that social cost of carbon is appropriate at the project level. It's not clear how we take the number that this generates and factor it into Section 7. But it is information that the public and decision makers can rely upon as they think about this issue. And so the commission did exactly everything that Sable Trail requires because Sable Trail does not require the next step that Ms. Datla is arguing for, which is to say, and then you have to quantify it, and then that quantification has to in some way, though they're not really sure how able to say, which I think is the same problem that the commission has, how do you take that number and then, stick it on the scales and start doing a Section 7 weighing? So I think the commission's action here is perfectly consistent with everything that this court has required. It's particularly consistent with everything this court has required because of the net negative finding that the commission made. The commission found, again, consistent with Sable Trail. And Judge Walker, your question suggested that Sable Trail says you have to consider full burn without offsets. Actually, Sable Trail acknowledges that one of the things that gas does is it allows coal to be retired. What Sable Trail went on to say is that doesn't mean you can't quantify emissions at all just because hypothetically it might allow you to retire coal. Rather, you have to quantify on both sides. You have to look at the foreseeable emissions and the foreseeable reductions and consider both of them together.
I guess I took FERC here to be kind of washing its hands of the reduction, saying, yes, we noted the emission reductions from closing the coal plant, but we didn't actually make that part of a basis for our decision.
So the FEIS does say we're not treating it as a baseline, but at JA 266 to 268, it's paragraphs 47, 48 of the certificate order, FERC makes a clear net negative finding. It says that it will reduce by upwards of 2 million tons per year emissions because of the retirement of coal. And the fact that the coal unit will retire because of these gas turbines coming online finds ample support and substantial evidence in the
And the
record.
petitioners say, no, the coal plant had to be retired and had long planned to be retired. The coal plant just wasn't making money anymore.
So it's true the coal plant long had to be retired, but the gas generators replacing it have also been long part of the plan. All the way back to the 2016 plan at page 46 says our 2016 plan calls for construction of a new combined cycle gas turbine in lieu of further investments. The retirement of this coal unit and the replacement of it with these gas turbines have always been gone hand in hand. The reason the gas turbines coming online is why they can cease making investments.
I hear this phrase, the line, social cost of carbon, arguably not appropriate at the project level. And maybe this would have been a better question for FERC, but it seems like most of the cases we get are project cases. So what is the non-project level scenario where social cost of carbon would be a better tool according to its proponents?
I think what would say is perhaps used in legislative rules. So maybe that's not FERC, maybe it's EPA, maybe it's some other agency, because of course FERC decides on the projects that are placed in front of it. But the problem at the project level is as I think everybody acknowledges, every ton of CO2 that goes into the atmosphere affects global warming in a non-differentiated way. So there is a point when many small impacts add up to one big impact, but it's, FERC has not determined, and I'm not sure anybody's really determined, except perhaps for the petitioners, how do you determine when this one small project, which again, has been noted, is actually facilitating the transition to renewables, is significantly contributing to global warming? So I think that tends to be the problem. And the problem also is you generate these gigantic numbers, even from the most minuscule projects. I think, and although I understand Ms. Statler is representing clients, so they have their own sort of unique and parochial interests, but I think the overall argument from environmental groups is essentially don't approve any gas project. But that's certainly not what the Natural Gas Act requires, and certainly the commission on this record where they have a gas turbine, which is only going to run 2 to 7% of the time to reinforce reliability when the sun doesn't shine or the wind doesn't blow, is certainly in the public convenience and necessity, unless the court has further questions.
Thank you. Ms. Statler, we'll give you 2 minutes.
Thank you, Your Honor. Just a couple of quick points. On the retirement issue, I was struck by the decision of both of my friends on the other side not to confront the lack of support for what FERC actually said, which is that there will be a reduction of downstream greenhouse gas emissions because this project will lead to the retirement of these plants. And just to kind of emphasize how contradictory that is with the document on which it relied, at J175, the final EIS says there's no such causal connection between the retirement of the coal plants and these turbines. At J224, it says there's no such causal connection with the broader plan to which my friend from Texas Gas referred to. And I think if you look at J48, which has a table produced by Centerpoint Energy laying out different options for different plans, you'll see the intuitive reason why just saying something is part of a plan does not create a causal connection. There are 4 plans laid out in that table. Every single one has the coal plants retiring, but not every single one has natural gas turbines providing backup power for intermittent renewable energy. And so I just don't think it's responsive at all to say that there's a plan here. And I want to respond, I think, Judge Katsas, to your question about, isn't this an easy case? And I think even if you set aside The problem.
Assuming the causal connection. I understand
Yeah,
you're
yeah.
challenging that. I
Exactly.
mean, if I accept the causal connection, it feels easy to me.
Yeah, so I think we would say two things. So obviously, we're strongly disagreeing with the idea that there is a net reduction for either NEPA or natural gas purposes. But also,
Why,
the explanation
I'm sorry,
that you,
why would that be?
why would there not be
Yeah,
a,
coal is very dirty relative to renewables.
so
and
the
natural
coal-fired,
gas. And again, assuming the connection, right? You're replacing a coal burning plant with mostly renewables, and then natural gas is the backup when you need it.
yeah, so I'll say two things. I think maybe there's some confusion in this case because the coal-fired power plants that have been retired are on the same physical site as the new natural gas turbines. But the coal-fired power plants are being retired and they're being replaced with renewable energy. The purpose of the natural gas plant is to say, given that we've made that shift, what needs to come in to provide backup renewable power? And that was the discussion about battery power and demand response and all that. But the second thing I'd like to close with is, even if it's a reasonable thing for FERC to have said, to say, look, this is an easy case, even if there's no direct causal connection, this is part of a bigger plan, and we think it's important to facilitate that plan. And so that's why we're concluding on net, these climate effects aren't significant. And this is how it weighs in the Natural Gas Act analysis. That's nowhere in this order at all. And the thing to do, if you think that's a reasonable explanation on the table, is to send it back to FERC and tell them that they're required to give that explanation rather than just not make a response. Thank you, Your Honors.
Any
Sorry.
questions? Okay. Thank you. The case is submitted.
Case number 23-5152. Carol A. Lewis and Douglas B. Sargent, on behalf of themselves and all others similarly situated, appellants, versus Xavier Becerra in his capacity as Secretary of the United States Department of Health and Human Services. Mr. Pistorino for the appellants, Mr. Koppel for the appellee.
Good morning, may it please the court. There are at least two just basic fundamental errors in the district court's decision in this case. First, the district court actually decided the merits of the case as a condition of class certification, when at the same time the Supreme Court has said at least twice, you don't do that. So just from the get-go, you don't decide the merits. Second, and again, in Amgen, the Supreme Court says an evaluation of the probable outcome on the merits is not properly part of the class certification decision. And there, the Supreme Court's even just citing the comments to Rule 23. Second, continuing on that, say, Judge Wall, the district court and the secretary's approach of deciding whether claims are viable, just whether they're viable, is barred by at least Eisen, Amgen, this court's decisions in Veneman, and also we would contend Moloch, and the rule itself. Moreover, again, it would...
Before you get too deeply into the merits, can I ask you about standing?
Yes.
Your clients won summary judgment and you're appealing. That's an odd procedural posture.
I might characterize a little bit differently. I'd say our clients lost summary judgment. The secretary moved for summary judgment.
Clients got relief on the merits. So the only question is, why can you appeal from an order that gives your clients all the relief on the merits you want? The most likely explanation is Roper says, well, if you appeal the denial of class certification and you win, then maybe there will be some mechanism for spreading costs getting costs from absent class members, right?
I think both Ropers and US Parole Commission both say that there's an independent interest in in being a representative of a class action. And again, for example,
Are you relying on that theory? Suppose I disagree with you about that. Suppose I think your clients need a particularized interest as individuals.
I think, at least as I understand both Ropers and US Parole Commission, I think that would be contrary to both of those, right? And again, both, I think Roper and US Parole Commission indicate that that one reason that we have Rule 23F for discretionary interlocutory appeal, right, is because the right to appeal is part of the premise of the whole thing, right? So again, your Honor's question about aren't we in the same position, or we've got everything we want. If I may, I just say I think that was exactly the situation of the plaintiffs in Roper, right? In Roper,
the court said they had a traditional individualized interest because if they reversed the denial of class certification, they might recover costs from absent class members that they would otherwise have to bear. That was the theory of Roper.
If I understood it correctly, I think in Roper, the defendant tendered to the plaintiffs everything they asked for. The plaintiffs refused and the court imposed it, just like here, the court imposed it. And what the Supreme Court, I think, said is, you can't do that. You can't impose exactly what they want on them as part of that and send it back. So again, if you're going to have it.
Is there any mechanism under which your clients in this case individually will be better off if you win the appeal on the class certification denial? I mean, I can think of two possibilities. One is you get costs from absent class members, which I think was the rationale of Roper. The other, which you haven't really articulated, but is lurking in the record, is you might get a higher EJA award of fees.
So I think, and I actually think this might be in US Parole Commission, right? What the Supreme Court came back to is the issue of why would we let people appeal the denial of class certification, even if judgment is entered in their favor? I think they went to exactly the issue you're raising. And they said, yes, we will, because one, they have the separate interest in representing the class members, right? And as part of that, they identified, again, one idea of the Rule 23, the whole Rule 23 process is spreading the costs of getting attorneys, So again, come back to, they would have an interest, again, in vindicating their interest as identified by the Supreme Court in being class representatives, and also an interest, again, in even being able to start the case.
Mr. Pistorino, though, have you argued that there's a cost-spreading rationale for maintaining this appeal?
Well, in our briefs.
Is that just something we should assume after Roper, that's always a reason for maintaining standing?
Yeah, so
Class action context?
My short answer would be yes. I think after Roper, and I think it's the US Parole Commission, right?
Is the short answer to Judge Rouse's first question no? Was this in your brief?
So no, I actually think our brief did cite to these.
Where in the brief?
I'll get you on reply. I'll get you the particular page numbers, but I know, for example, I did cite this exact thing about, I think it's from US Parole Commission, talking about
spreading litigation costs.
Yes. And again, if you just think about it practically, if you were wanting to start a class action and you told the potential attorneys, again, the idea is to get potential attorneys. You said, well, if my individual guy wins, right? If the class representatives wins, the plaintiff's able to, quote unquote, buy them off. The case will be completely over. You wouldn't be able to appeal. You're contending that the simply enter of judgment over their objection in favor of the named representatives deprives them of standing. Again, it would just be inconsistent with Roper and deposit guarantee, and no attorney would take that case, right? Oh, I'm going to get whatever you could get for an individual person versus a class action overall.
So you're relying on the Roper rationale, not on the Garrity rationale or the US Parole Commission rationale?
At least I understand it. I think they're both, because I recall correctly.
Your broader rationale is none of this matters because the putative class rep has this private attorney general interest in representing the class, which is distinct from the merits, right?
Correct.
That's a broad reading of Roper. It might be supported by Garrity. We will deal with that as a legal argument.
Right.
Suppose I disagree with that reading of the cases and think narrower reading of Roper, which is you need to show that the individual putative class reps, the named plaintiffs, have to show an individualized concrete injury. Do you have an argument on that point?
I guess maybe my short answer would be no. So if the case is from the Supreme Court, if Roper and U.S. Parole Commission do not stand for the proposition, right, that even if a judgment is entered in favor of the named plaintiffs, they lose the right to appeal because they don't have standing, right? Judgment entered in their favor. They lose the right to appeal because they no longer have standing. That will be a completely different rule. That's not what the Supreme Court said in those cases.
Okay.
Individualized interest, the whole idea of Rule 23, let's get all the cases together. Let's make it have the prospect of having a class counsel, right, by litigating cases together when the individual litigation of each case individually would be uneconomic, as it would be here. Again, the average claim here, we say, is about $4,000. No one's going to litigate the case at this point for 5.5 years, right? No attorney's going to litigate a case for 5.5 years through appeal for $4,000. The only way you get a case, again, you combine them all together. And as part of being able to start that whole process, you've got to be able to appeal denials of class certification or the Rule 23F discretionary appeals, as we say in our papers, right? It would transform that into a case dispositive motion. Right? Wouldn't be discretionary. We consider its disfavored approach. We only consider it in special circumstances, right? If you were to lose the class certification at that stage, when you know your underlying case has merit, then the case would be over. You'd have to appeal to win it. And again, just contrary to Roper, contrary to U.S. Parole Commission, contrary to the discretionary nature of Rule 23.
And when you talk about interest, do you mean the attorney's interests or the plaintiff's interest?
The plaintiff's interest in being a class representative, again, the Supreme Court identified it as a separate interest distinct from their interest in winning on the underlying merits. And as part of their interest in being a class representative and be able to bring the case, again, what the Supreme Court said is actually the attorney's fees is a significant component of that. How could Ms. Lewis, one of the named representatives, how could she get an attorney to take her case on, prepared to litigate it again for 5.5 years, when the underlying claim, I think in Ms. Lewis's case, is like, what, $1,500, something like that? She couldn't afford to fund the litigation. No attorney would take it if the potential award at the end of the day is $1,500 for Ms. Lewis. So again, I think it would just be totally contrary to, again, what the Supreme Court has said in these cases. It would transform Rule 23F to having a circuit court accept the discretionary, disfavored Rule 23F motion into a dispositive motion on the case. Every case that would be denied, again, you'd have to be a completely different world. And what the Supreme Court said in those cases is because of the ability to appeal a class certification decision after judgment in favor of the named representatives, that's why they said, well, we're happy to have Rule 23F be discretionary.
In a case like this, it's an APA-like action. It's under the Medicare statute, but the award, as I understand it, it's not an award of money damages. It's setting aside agency action. How does counsel get funded? I assume it's through some sort of contingency fee, and you hope you get an EJO award at the end of the case, right?
So in terms of the actual component here.
But I'm not asking you about your private conduct.
No.
In general, because what I'm struggling with is it just, in a damages class, I get this, where Roper says what Roper says, and it's easy to understand. It's easy to imagine a mechanism in which if the class gets certified, there's some mechanism for adjusting the damages awards to the absent class member to fund the thing. And that makes the individual named plaintiffs better off. I'm just not sure that can work in an APA-like case, which is why I'm pressing you on what's the individualized interest at this point.
Sure. So just coming back more generally, I think you're right in some sense. The way you're phrasing it is that the ultimate award, again, and you might be able to tell from the papers, we've litigated this issue 3 times already in the prior cases where attorney's fees were awarded, right? So the judgment that comes out is not you win $4,000. What you win is an order to the secretary to rescind the denial and provide coverage. So one way that you can get attorney's fees, again, as we've won in 3 other cases well, actually 4 other cases, is you could get it under EJA, but I don't know that that's the only way that you could get it. I think you could actually get it under just traditional straight contingency agreement, right? Contingency agreement when the class members, right? When the denial is reversed, the class members would get the money they were denied as for the coverage. I think you could get a component of that pursuant to contingency agreement. So it could actually be both in both instances.
Mr. Reno, I had a question. If we do get to the merits, and assume we disagree with you that the district court could properly exclude untimely and unexhausted claims, do you dispute that if those claims are excluded, then there are only 17 viable claims?
Yeah, yes.
You dispute that number?
Yes, it's
Okay.
yes. So again,
Where
you're
do you
correct.
where do you dispute that in your briefing?
Yeah, I think it's actually, I want to say it's page 10 of the reply brief in particular, but in general, that number is disputed. As we've said, and I think actually district court's opinion actually summarizes my position as it's been all along. Again, we say you don't get to the merits, but at a minimum, assuming they were pled and assuming you could in that hypothetical world, what you know is that the claims that would still be live, no matter what else happened, were all the claims that were live on the day the case was filed because of American Pipe. So we cited it below. I know we cited it in our papers. Because of American Pipe, every claim, by every person that was live on the day the complaint was filed in December 2018 is in the case because American Pipe stops all that. So again, I know in our papers, for example, we cite, if you look at, hold on, let's get to the JA site real quick here. If you look at JA 357 through 358, I actually provided numbers sort of a couple different ways, but taking the secretary's position that it should be claims that 60 days before the complaint was filed, at that time it would be 117,000 claims filed by 34,000 people. So it's not 17, and as we say, it's premised on simply just ignoring American Pipe. So again, you got American Pipe, the case could never be smaller than 34,000 people. I know the secretary cites to a case called Medellin from the 8th Circuit, where it's the exact same thing. They sort of, again, actually quite instructive. They broke the potential class members out into 4 groups, right? And then group 3 was all the claims that were live when the complaint was filed. And of course, those will all go on. And group 4 was the claims that came after the complaint was filed. And again, I know what we say here is, if you look at the last bit of discovery we have, again, I want to make this point, with regard to Part B claims, original Medicare claims, right? The last bit of discovery we have is from July 2019. And at that point, we calculate the secretary was denying about 13,000 claims per month. And what we know from all this activity, go back into it, basically the secretary stopped applying that policy, they say, in May 2022. So you got about another 2.5, 3 years in there when claims are increasing at 13,000 a month. So you never get to 17. The 17 comes from assuming you ignore American Pipe. How many people went all the way through these 5 levels of process and got to the point where they could file a suit in district court? Again, just disregarding the whole idea of a class action, that you shouldn't have to do all that. That's where their 17 comes from. We found 17 people, that weren't misled by all this stuff, went through the 5 levels and got to the point where they could have filed suit in district court. But again, American Pipe says you don't do that. You don't do that. I'm sorry, do you not have a question? Okay. So just coming back again, I know that. So again, this first thing, this is just the poster child for a class action, right? You got more than 375,000 claims through July 2019, filed by 90,000 people. On average, again, as we calculated from the limited discovery we have from the secretary, the claims for about $4,000. It would be uneconomic to litigate each one. Every single one of the 90,000 people, they have the exact same theory of liability.
That's true, but you do have the individualized defenses.
Which defenses are you referring to, Your Honor?
Exhaustion, statute of limitations, amount in controversy.
So I don't understand the amount of controversy to have been an individualized defense here. I'm not aware of that. Likewise, with regard to exhaustion and statute of limitations. Again, as we say in our papers, problem one seems like it wasn't ever pled. Never pled. So that seems a problem under Rule 8, right? Must affirmatively plead. Never happens. Even assuming it had happened from a class certification perspective, as we say, under 23A, it's not even relevant to 23A. Doesn't even come close to 23A. It's not a factor to be considered for under 23B3. I'm sorry, 23B2. And with regard to 23B3, as we say, it wouldn't be individualized. Like, for example, one thing would be is for claims filed after January 2017, appeal of them would be futile. The secretary, again, from Genesis litigation in large part, in 2017, the secretary, without complying with notice and comment, issued a decision. Again, if you want to see it, I think we got at JA 688 through 703, where the secretary got a doctor, Mr. McConway, to say that the life-saving CGM doesn't serve a medical purpose, not primarily and customarily used to serve a medical purpose. And based on the illegal issuance of that, again, adjudicated bad faith position, based on that adjudicated bad faith position, again, the secretary's regulations say that everybody within Medicare, all the way through from the initial consideration to redetermination, through reconsideration, through the ALJ, through the MAC, were required to deny CGM claims. So we want to talk about futility. They've got a mandatory policy saying that they could never come to an opposite conclusion. So is that particularized? Doesn't sound like it to me. And that's just picking one. So because of my base position, we should never look at the merits at this stage. And as we read every case, including Veneman from this court, saying you can't do that, right? Inappropriately mixed the merits with class consideration. You couldn't do it. But even if you were, again, I know I identified five basic bases in our reply brief of these would be just straight up common issues. How about the issue about what did the initial denial say? Did they have the explanations complying with the statute? I haven't seen one that said that. And I've only seen the ones, again, I think an important point, I've only seen the ones for the Part B cases, right? We know in 90,000 of them, we contend, they just flat out lied to them that there's some statute that precludes it and there's no such statute. Nevertheless, it doesn't comply with the statute itself, that the denial has to be calculated in a manner to be understood by by the beneficiary, a regular person. So they don't, of the ones we've been able to see, right? / they lied to them, told them the wrong purpose. And again, I think an important point that really comes back to some of the other issues here is there are about 25,000 Part C people, Medicare Advantage people that would be in the class through this date. There's never been a shred of discovery with regard to those people. What were they told, right? Were they told anything? We don't know. And again, a big problem here, again, coming back to the issue about trying to decide the merits as part of class certification. Where does that come from? Judge Walton found, right, that those people failed to exhaust, or I'm sorry, that exhaustion should not be waived for those people. On what evidence? Since nobody knows what they've been told because the denial of the discovery of it is out there. Again, it's just, I don't know, I guess they lose when nobody knows who they are. There's no evidence about it.
Why'd you wrap up?
Thank you. So just wrap up very quickly, and I'll sit down. If I may, again, as we say in our briefs, we also hope that the court will order the class certified. We've been here 5.5 years. This is not in compliance with Rule 23, right? This is not early practicable date. It's the first thing in a class action case, and we're standing here arguing about it. Again, on rationale directly contradicted by the Supreme Court, and as we also request, we request the court reassign the case for the reasons set forth in our brief. Thank you, Your Honors.
Mr. Capel, you didn't address standing, but we have to deal with it. Does the government have any thoughts? You've heard the colloquy.
Yes, may it please the court. We did not address standing in our brief. We do think that this case falls pretty close to Roper, although I do agree.
Close to Roper in what sense? That the mere fact of being a class rep, a putative class rep, is enough to give standing, or that this plaintiff has some concrete pocketbook injury because of the way fees or costs might be shifted?
In the first sense, in the sense that being a
And you think
lead
that's
plaintiff.
sufficient?
Well, not necessarily. So this is what I was going to get to. I do think that there is a lot of truth, and you are correct in what you I think were saying, that especially in a case against the government where the fees are going to be paid most likely from under EJA,
Right.
there is no interest in spreading litigation costs among the class. If Ms. Lewis
So
is
the Roper rationale of shifting from absent class members to the named plaintiff doesn't seem to work.
that's right, and
EJA rationale might work, which is if they win on the issue that they want to put before us, maybe the EJA award to the named plaintiff is higher.
Well, there's no EJA award. Well, the plaintiff's
If they-
attorney certainly has an interest here. The EJA award to the plaintiff's attorney is going to be higher.
Payable to the prevailing party.
Nonetheless, I think that is really the attorney's interest. I don't think that is the plaintiff's interest. So I do think that.
So you're suggesting this broader reading of Roper?
Not necessarily. We haven't taken a position on that. We haven't taken a position on it, although I certainly
Okay.
understand that this case is certainly distinguishable.
Okay, I'll let you go on. Thank you.
Until today, I think, I did not understand, I don't think plaintiffs at all disputed that of the class they sought to certify, there were only 17 individuals in the same boat as the named plaintiffs with claims that were administratively exhausted and timely under the 60-day statute of limitations. Plaintiffs now say that on page 10 of their reply brief, they made this argument that there are more plaintiffs. There may be an oblique reference there. Even if the reference were clear, you can't preserve an argument in a reply brief. You certainly can't preserve an argument by raising it the first time at oral argument. Any argument that there are more than 17 unnamed plaintiffs with timely and exhausted claims is long forfeited at this point. And even if it weren't forfeited, I'll just note that plaintiffs suggest that the pendency of this class action told the statute of limitations for putative class members. That much is true, but it did not relieve any putative class members of any burden to exhaust administrative remedies. So any claims that were still working their way through the administrative process, those putative class members had to continue that administrative process. American Pipe deals with tolling of the statute of limitations. It does not deal with, it does not say that the pendency of a class action waives the requirement to exhaust administrative remedies.
Can I just ask you a factual question? I'm wondering, with the change in policy at HHS, whether the agency is now just as a routine matter paying these claims for continuous glucose monitors.
The agency is paying claims as they come up now, certainly,
What
in
about
addition
past
to
claims?
under the policy, past claims that that are still working their way through the administrative process, or where there is still the claimant is still within the window for an appeal, whether administrative appeal or to seek judicial review, the agency is paying those claims. So the other 99.98% of putative class members here couldn't meet the basic threshold requirements to state a claim under the Medicare Act because their claims were not administratively exhausted and not timely. And plaintiffs told the district court that they would explain at some later point why all those other putative class members could bring their claims nonetheless. But they steadfastly refused to make that argument at the class certification stage. Instead, plaintiffs asked the district court to certify a class now and figure out the proper number of claimants later. And that position would relieve plaintiffs of their burden to establish each of the requirements under Rule 23A, including numerosity. Specifically, would circumvent that numerosity requirement.
For class certification purposes, question is not whether that exhaustion, whether your exhaustion defense has merit, right? It's whether you have to adjudicate it on an individualized basis, right?
No, I think that, so if you were looking at this under the Rule 23b3 predominance prong, I think that you would be looking at whether whether that exhaustion defense can be adjudicated on a class-wide basis.
Individualized or
That's
not.
right.
If it's a global defense, then his Eisen point is right. You don't decide the merits.
Only with regard to predominance. You still need to establish numerosity. You also need to establish typicality. The exhaustion defense, which the named plaintiffs here had exhausted their claims, they had timely claims. So this issue also goes to typicality. The district court here only had to reach numerosity. Under Bowen, the district court was correct to determine at the outset whether the putative class members had exhausted and timely claims, or whether they could waive the exhaustion requirement and toll the statute of limitations. And because they could not, they were not proper members of that class. This court said in Zhang versus USCIS that a class certification order can't revive untimely claims, nor can time-barred claimants be included in a class action. And that's exactly the case here. The district court applied that rule, applied Bowen, and applied the numerous cases from out of circuit to first determine whether the putative class members had viable claims, whether they could meet these threshold requirements of timeliness and exhaustion. Because they couldn't, the district court excluded those individuals, was left with a class of 17 unnamed plaintiffs, and said that doesn't meet the numerosity requirement of Rule 23A. In addition to Bowen and Zhang, this case, I think, is nearly identical, presents very similar facts to National Association of Government Employees from the Fifth Circuit, Gilchrist v. Bolger, which we cite in our brief from the 11th Circuit. In both of those cases, the district court denied class certification, finding that most of the putative class members had untimely claims, and the number of class members with timely claims were, in one case, was 11, and in another case, the court couldn't figure out exactly how many individuals had timely claims. And so the court said that the plaintiffs in those cases couldn't establish the numerosity requirement of Rule 23.
Do you think that the district judge in this case has proceeded more slowly than is appropriate?
I don't know that whether the district court has proceeded more slowly than is appropriate. I don't want to opine on that. I would certainly say that reassignment in this case is unwarranted. In 4.5 years, the district court decided a motion to dismiss, a motion for preliminary injunction, a motion for class certification, numerous discovery motions, and then entered final judgment. Plaintiffs don't like the way that the case turned out. They disagree with how the court decided many of those motions, but that doesn't mean that this case, as they say, has languished on the docket. It certainly has not. And in any event, I'm
not sure I see the gap between it has not languished on the docket, but you're unwilling to say whether the district court has proceeded with a slowness that is inappropriate.
I don't. Their claim on appeal, their argument on appeal is that the case should be reassigned. We certainly don't think that there are any facts here warranting reassignment.
I mean, part of why they say it should be reassigned is they say it languished on the docket. You say it hasn't languished on the docket, but if that's true, then it seems like you would be quick to say the district court proceeded with a speed that was appropriate.
I'm not, I did not litigate this in the district court. I can't speak to what is appropriate. I don't know. Appropriate within the realm of, certainly not warranting reassignment. Absolutely.
Okay.
Fair
enough.
Yeah.
Sounds good.
We ask that the court affirm the decision below.
Thank you.
Thank you.
Thank you very much.
I'll give you 2 minutes.
Thank you, Your Honor. Judge Walker, I wanted to go to your points where we argued these things in our briefs. I think in our opening brief, with regard to Roper and attorney's fees and that kind of thing, I think if you look at page 33 of our opening brief, and also I think if you look at pages 15, 19, and 20 of our reply briefs.
So reply brief isn't enough to save you from forfeiture. And I thought you might say page 33 for your opening brief. You do talk for about a paragraph about Roper. you don't ever say you have an interest in spreading the litigation costs. And I guess maybe what you'll say is, well, all we had to do was cite Roper for a more general point, and that preserves an argument that you wanted to spread the litigation costs. Is that?
I think I believe if I'm correct, I think in our opening brief, we have a whole section, I think the very first one saying the case is not moot for these same reasons, right? Because you have the ability, they have the independent interest.
Where do you argue that you have an interest in spreading the litigation costs?
I don't believe we argued that you have an interest in spreading the litigation costs in the opening brief, because they raised that in their opposition brief, contending, I think, for example, that the plaintiffs are no longer typical. So as a response to that, we're relying again on Roper.
And then on the issue of spreading litigation costs versus just increasing litigation costs. So I get that, you know, if you could prolong the case, you would increase the litigation costs and then get more from EJA. But I'm not sure how you will be spreading the litigation costs that have already accumulated.
I'm struggling with your question to say, in the first sense, of course, our goal has never been to prolong the litigation. Our goal since the beginning, I think actually since some of the first hearing before the district court has said, I'm ready to move for summary judgment.
Maybe ask, I didn't ask the question very well. But as of right now, can you get the hours that you've worked on this case? Can you get paid for that?
I would say we don't know, right? We don't know because again, the court would have to assess it, right? Again, if you limited yourself.
So if the court assessed it, absent class certification, if the court assessed it the way you want the court to assess it, you could get paid for the hours you've worked.
I think when you say the court would assess it, if under EJA, again, there's a prong, I think it's paragraph B and paragraph D, a court would first have to decide that the government's position lacks substantial certification, or I think it's under D, that the government's position, again, was in bad faith. So if the court were to make those determinations under either of those two things, then yes, you could get, different rates depending upon which one, you could get paid on under.
You need to do that even if you got class certification, right?
Well, again, if you're ultimately you would be faced with that choice of doing that. That's correct.
I'm just not seeing how class certification helps you get compensated more for the work that you've already done.
So again, as I said before, I think there could be two components of attorney fee compensation. Again, as the Supreme Court says, the contingency fees play a significant role in the class action context. So as I said before, I think you could get attorney's fees under EJA and under a contingency fee agreement. So again, your starting point is the broader the class, again, the more potential awards attorney's fees could be. If I can, I just wanted to come back to a couple points. I heard Bowen again. I keep on hearing that, and I know we've submitted a motion for judicial notice where I provided the court with an actual copy of Judge Weinstein's order certifying the class within 3 months of the Bowen case being filed. As I said all along, all the cases that I hear from the secretary, all the cases that are ever cited fall into two camps, right? One, where the defendant files a motion aimed at the named plaintiffs, and the named plaintiffs who have attorneys and know of the case oppose that and something happens in some way resolved. I think that might be the Naga case. Many cases fall in that category. You move against the named plaintiffs, you fail to exhaust, for example, and the result on that determination, right, could control the class certification. That's one of the big groups. Every other case that I've ever heard them cite, it's after a class is certified and after the class members have notice and counsel to champion their interests that the court looks at the merits and then makes a determination and then may modify the class or not. In Bowen, class wasn't modified later, but there was never, there is no case where a court first out of the gate decides the merits with regard to the absent class members. Geez, you think it would be a good idea? Maybe they should know of the case. Maybe they should have attorneys to represent them. That would seem like a good thing.
Thank you very much.
Thank you, Your Honor.
Case number 23-5149. J. Gregory Sidak versus United States International Trade Commission et al. Appellants. Mr. Salzman for the appellants, Mr. Landau for the appellee.
Whenever you're ready.
Thank you. Good morning, and may it please the court, Joshua Salzman on behalf of the International Trade Commission. The district court here committed a series of errors in entering an injunction that will prevent the commission from even determining whether plaintiff Gregory Sidak improperly retained the confidential business information of private companies like Apple and Intel in violation of a voluntarily assumed obligation.
Mr. Salzman, if I can ask you a question at the threshold, is it the ITC's position that this investigation is based solely on the protective order?
So I think the enforcement here is predicated on the protective order, but the protective order goes hand in hand and is only applicable to Mr. Sidak because of his separate agreement signed 3 months later in November of 2017 when he signed that acknowledgement that you can find at JA 48.
But the investigation with respect to whether sanctions should be imposed is based on the protective order, solely on the protective order.
I agree that under the commission regulations that form the basis for the investigation here, what he is being investigated for, and I do want to emphasize that we are still just at the preliminary phases of that investigation, is a possible breach of the protective order. But I don't think you can analyze the protective order in a vacuum without recognizing that the reason we are here is because when that protective order issued in August of 2017, it had no adverse impact on Mr. Sidak. But
I know the merits aren't.
Sorry, can I just ask one follow-up to that, which is, so I just want to be just clear that the ITC is not relying on, the fact that Mr. Sidak may have violated some separate statutory or regulatory requirement, that the investigation is based solely on the violation of the protective order.
That is how the letter from the commission secretary is framed. It is,
Okay,
it is framed in terms of the protective order.
You are not claiming any broader investigative authority.
Yes.
I think that turns out to be actually quite important. So thank you.
And I'm happy to engage on that and try to explain to you why I think under the facts here. But I
was just going to ask you, what is the merits aren't directly before us, but what is the government's colorable argument for being able to have a proceeding whose sole purpose is to enforce an order entered by an unconstitutionally appointed ALJ?
I think it sounds shocking when you say the order is unconstitutional. It has a lot of shock value, but it's actually much less remarkable than you might think. So even the district court here, for example, seemed to assume that this order could still be enforced against Apple and Qualcomm. And for example, in the Ryder case, the Supreme Court held that military judges were unconstitutionally appointed. It provided a remedy to the plaintiff there. It said there were probably going to be 7 to 10 additional cases that would be affected by its ruling. But the court suggested that habeas claims by people whose cases had otherwise become final would almost surely fail. And the reason is because for non-jurisdictional defects, like an appointments clause defect, finality has always been understood to continue to severely restrict the scope of available relief. And with good reason, the Supreme Court has recognized for hundreds of years that it would be horribly disruptive if a defect in title could somehow unsettle long-settled expectations. And I think that's particularly true here with the reliance interests.
So that then, I guess, comes back to the argument you did make about untimeliness. And, he should have teed this up. We've got 2 different proceedings, right? One is Qualcomm versus Apple before an unconstitutionally appointed ALJ. The other one is ITC versus, is it Sidak, for some sort of enforcement action before a lawfully constituted ITC.
That's right, Your Honor. But first of all, on the merits,
it's a very odd It's
This is,
very odd to imagine, if that's the right way of thinking about it, the witness, the expert witness sort of has an obligation to raise the appointments clause issue in the first proceeding.
so I want to distinguish between two different merits arguments we've made, since we seem to have, and I'm fine with this, we seem to have skipped over the ripeness argument
No,
and are on the,
we'll come back to it, don't
we'll come
worry.
back to that, I know. But I want to distinguish between two arguments because they have different implications. One is sort of a forfeiture, you might think of it as a consent argument. In November, when he signed that agreement, in November of 2017, when he signed it, he agreed, in his own words, he'd read the protective order and agreed to abide by his terms. At that point, he voluntarily relinquished any challenge to having to abide by the restrictions. And remember, he was doing that because he wanted a benefit. He wanted access to confidential information that he was otherwise statutorily barred from receiving. He wanted to be able to earn a fee as an expert witness for Qualcomm. And in order to get the documents necessary to perform that function, he had to agree to abide by reasonable safeguards to ensure that they were only used for proper purposes. So that's argument one.
Sorry, I have a question about that, which
Yep.
is where does the authority come then to bind Mr. Sidak? Is it from his consent or is it from the protective order that was issued by the ALJ?
I would say it comes from his consent. It comes from,
And why?
well, the protective order. So at the time that the protective order was issued in August of 2017, it did not bar Mr. Sidak from anything. There was a statute. There was a statutory backdrop.
In general terms, it applies to anybody who participates in the proceeding. And then the order itself requires people who participate to sign a letter of acknowledgement. But the order by its terms, even, without a letter of acknowledgement, would apply to an expert like Mr. Sidak. It seems to me.
Well, you start from a statutory backdrop, right? I think it's important to understand that the protective orders are rising against the backdrop of Section 1337N. That's a categorical prohibition on sharing confidential information disclosed to the commission, except as authorized by the protective order. So the protective order is in some case, you could characterize it as the permission slip. You would be barred, that Qualcomm would have been barred from sharing Apple and Intel's information with Mr. Sidak, but for the protective order. And the protective order provides a mechanism that allows for sharing, but also, as one would reasonably expect, imposes reasonable conditions, says only use it for purposes of this investigation, keep the material safe, destroy or return it at the termination of the proceeding. And anybody who wants the benefit of being able to take advantage of that authorization, that exception to the statute, the mechanism for sharing information, has to agree to abide by reasonable terms. And that's what Mr. Sidak.
That's right. You should be going after Qualcomm, not Sidak.
Well, I don't think that's right under the circumstances here because Mr. Sidak made representations. Everybody reasonably relied on the representations that he would abide by the conditions that went hand in hand with his receipt of that information.
But as a legal matter, the conditions are void. There never were any conditions. It was as if something called a protective order was issued by 4 or 5 random people in the phone book, and they called it an ITC protective order. I think, right?
I actually don't agree with that, Your Honor. And the reason I would say that is because appointments clause defects are non-jurisdictional. They certainly can be a basis when timely raised for setting aside governmental action. But it is not that as if they never occurred or that an order taken by an improperly appointed official can never be given legal effect, even years later and when first challenged through a collateral action. I think Mr. Sidak here had the opportunity to raise the issue to the committee.
No, go ahead.
No,
I mean, so you're trying to separate the consent and voluntariness aspect of your merits argument from the consent aspect from the timeliness aspect.
I think those are two separate arguments.
Okay, so on the voluntariness point, I mean, if a private party goes to work for the government, wants to earn a living like this guy, and is forced to sign a non-disclosure agreement, to get access to classified information or government information or whatever, right? That person is not thereby barred from bringing a First Amendment challenge to argue that the non-disclosure is overbroad or whatever, right? So consent can't bar the constitutional challenge to the governmentally imposed non-disclosure requirement.
Well, I think I don't want to speak in such categorical terms because, for example, in CFTC versus Shore, and then the Federal Circuit has a couple of cases involving their inter partes review scheme that we've cited, the Sienna Corp and the Valve case. When you seek out a particular judicial forum, sometimes that can go hand in hand with relinquishing a constitutional challenge, and that's to defeat sandbagging.
I'll refine it just a little bit. Doesn't automatic, the fact of the voluntary aspect of this is not always a showstopper.
I'm not going to say it's always dispositive, but I'm saying in analogous circumstances.
Seems a little different. The litigant who goes to the ITC seems a little different from the expert who's, this is what he does. He supports clients wherever they are.
Fair enough. He voluntarily chose this engagement. He voluntarily chose to put his name on a document where he assured the commission, ensured appellant Intel that he would abide by some reasonable restrictions to safeguard that information.
Could Qualcomm have gone to an Article 3 or other tribunal, or does this sort of proceeding only go to the ITC?
The specific remedy that Qualcomm was seeking, this was patent infringement litigation. That's obviously certainly the kind of issue that can be brought in district court. The ITC offers a particular remedy, which is an exclusion order. Essentially, all of the iPhones would have been stopped at the border.
So it seems a little aggressive to say, oh, they made a choice to go to the forum with the questionably appointed judge, so tough luck.
So again,
that's the forum that Congress has made available for this kind of.
And I think that's Qualcomm. I think we can separately think about Mr. Sidak here, who chose to take an engagement and chose to accept access to certain documents on certain reasonable conditions. And once Apple and Intel have relied on those representations and relied on the fact that the commission will be there to enforce the security as Congress intended through 1337N.
Let me ask you about one of ITC's other regulations, though, about sanctioning non-signatories to protective orders, right? So that regulation provides that ordinarily, if someone is not a signatory, they can't be held to violate a protective order. However, if there's good cause shown, even a non-signatory can be sanctioned for violating a protective order. So doesn't that suggest that the protective orders have some authority or some legal force absent the consent of a person who's a signatory to the protective order? Because you can apparently, the ITC can sanction someone who's a non-signatory.
Yeah, and that may well be. We've relied here on his status as a signatory, which I think makes this at least a much easier case. But
that's the government's litigating position, but it doesn't tell us where the authority comes from, right? Because if the protective order is the thing that is doing the work, and that was issued by a non-constitutional ALJ, that's a problem. If the consent is what's doing the work, then maybe, of course, it might be less of a problem.
Yeah.
But it seems like on the ITC's own terms, they're recognizing that the protective orders have legal authority separate from consent.
So if you're asking where the statutory authority to issue these are and to enforce them, I'd refer the court to 19 USC 1335, which is a broad delegation of rulemaking authority, and then 1337N, which I've referenced several times, and specifically contemplates that the commission will establish regulations and procedures for promulgating protective orders, because otherwise that's the only mechanism through which you have an exception to 1337N's otherwise categorical bar on the disclosure of the information.
I'm not suggesting they didn't have authority to issue the protective order. In a statutory sense. But But if the protective order is what is binding on Mr. Sidak, and that order was issued without constitutional authority, then that's a problem.
Well, it's only a problem, assuming you get past consent, it's only a problem if you think he has raised a timely challenge. Because of course, Lucia, Ryder, they have always taken pains to emphasize that they granted relief to parties who raised timely challenges. Ryder specifically, as I mentioned earlier, distinguished any kind of collateral attack through habeas. And here, there is a value in repose. That's the principle that Ryder and Lucia carry forward from the de facto officer doctrine. This idea that it would be incredibly disruptive, that chaos would result if every act taken by an unconstitutionally appointed officer was subject to challenge collaterally years after the proceeding had gone vital.
And the defendant who's convicted in an unconstitutional proceeding has direct review, Article 3 review, and once the Supreme Court denies cert, that's over. It's over, and habeas is different, right? Tough luck. That's different from here.
So
I mean, Sidak as prospective administrative defendant facing exposure, that happens when they notice the enforcement proceeding.
So Sidak, I think his brief definitely tries to harp on exactly that theme, but I think it's belied by the content of the protective order. From the moment he signed it, he was under certain obligations to safeguard information, to limit his use of it in certain ways, to report leaks. And then I think the clearest example is in April of 2019, when the 1065 investigation terminated, he was under an affirmative obligation enforceable by the commission to return or destroy all of the confidential information that he had received through the proceeding. His rights were directly at issue. He had obligations at that time.
And how exactly would you have had him raise this in the original proceeding?
Okay.
Or run into district court or file, get separate counsel, motion of witness to
So I
have
think there were,
ALJ declared unconstitutionally appointed?
so there are various stages at which he could have done it. And I'm not going to tell you whether all of these would have worked.
Give me the most
So-
plausible one, because any of them
So
strike me as odd.
Okay, well, I've got three, and you maybe, so first, when this document is first put in front of him, he had an option not to sign, he had an option to sign,
Yeah,
but
that's
say,
your
I don't
consent.
see,
That's
no,
your
but flag, if you are going to represent to a governmental body and to private parties who are depending on that governmental body to protect their information, that you intend to abide by a series of conditions, that you have doubts about its enforceability, you should do that in a contemporaneous way. And I do want to emphasize, it's not like Lucia was an unknown issue. This had already, I think, been by this court in November of 2017. In fact, I think we filed our cert petition in November of 2017, or it was a brief in opposition nominally. But, and then it was decided by June of 2018. So this issue was very much out in the world. The Supreme Court was granting cert at around this very same time. But then do I think the very sophisticated counsel who are representing Qualcomm and Apple in this proceeding were aware of Lucia? Absolutely. But so he was a paid expert for Qualcomm. He was certainly on the same team, to put it nominally, as Qualcomm's lawyers in the case. But
those lawyers know they're doing well to sue. Not from your end.
no, they certainly owed it to the company, not to him. But as far as I know, he wasn't separately represented. I'm not saying that. What I am saying is that if you are going to sign a document agreeing to abide by certain conditions, particularly as part of a quid pro quo, you're getting the benefit of the access that it provides. I don't think it's fair to complain about it afterwards, but
That's what witnesses are It's a good thing that we have expert witnesses.
Absolutely.
And we would have less of them if they didn't get paid.
I have no issue with any of that. I just think that if you sign a document saying, I'm going to keep your secrets safe, that you should probably keep those secrets safe, and that if you consent to enforcement of that.
Or whether it is, no, you don't think that every expert witness should hire an attorney, right?
No, I don't. But I do think that when you sign a document, you should make certain that you intend to, that you're serious about abiding by it, and that if you have doubts about its enforceability, you should give notice. But I did say I had 3 answers to Judge Katsas. If I'm happy to answer follow-up, but I didn't want to forget that.
One is should have raised that when you signed
Right.
the order, sign it.
With reservations, yeah, or attach something noting his doubts about its enforceability. So that's option 1. Option 2 is certainly at any point while the matter was before the commission, he could have either filed even an informal letter, given notice, so the parties were at least aware. Because the reason I harp on this, and I realize it would be an unusual thing, but if he had given notice while this was before the commission could have taken corrective action. They could have shored this up and put it on clear constitutional footing. And instead, we've ended up in a situation where the district court is just giving him a permanent get-out-of-jail-free card. So even in advance of Lucia, first of all, I want to emphasize that even before Lucia was decided, in anticipation of that decision, the full commission did ratify the appointments of the ALJs. So then you get into the separate question of what to do about the individual actions. And as I've mentioned a few times and really do want to underscore, appointments clause concerns aren't jurisdictional. And therefore, the commission, I think, deferred to the parties. I can't get inside the heads of what was going on there. What I can tell you, I'm not aware of them not, but if you're about to tell me they don't, I just don't know.
It says there are 5 serving commissioners, but the website for ITC says there are 4, and it suggests that 3 of those are serving past their statutory terms. Now, it could well be that the website is just outdated. I don't, again, I'm asking you to give their attorney.
Yeah, I apologize. This wasn't something that I focused on in preparing for today's argument. I'd be happy to supply the court with, and I'll talk to my client right after this and let the court know. But yeah, no, I understand, and I apologize that just wasn't something that I thought was going to be put at issue here. But to return to the fundamental question here, because these are non-jurisdictional, if Apple was happy with this and Qualcomm was happy with this, and the litigation is moving forward, there was no affirmative obligation on the part of the commission or the ALJ to take specific corrective action. And there was some onus on a party who wanted to get out from under an action that had been taken by the ALJ prior to the ratification to note it for the commission so that the commission could take that corrective action. And this brings me to the third and final point at which Mr. Sidak could have done something. Number 2 is, at some point, send in a letter. They emphasize, for example, that Professor Calabresi submitted a letter while the matter was before the commission. Certainly, he could have done the same thing. And the third thing is he could have filed basically the suit he ultimately filed, but filed it in April, certainly not later than April of 2019. A suit in which court, yes. Yeah, essentially asserting, I think the suit in April of 2019 would have effectively said, I am currently under the purported compulsion to return or destroy documents. I don't want to return or destroy those documents. I think this order is unenforceable, and accordingly, I'm seeking a declaratory judgment that that obligation is null and void. So I think that would have been the time. But to give no notice at all of a possible intent not to comply with the voluntary undertaken obligation, to allow the commission, to allow the private parties to rely on the assumption that he's going to do what he said he was going to do, and only then, when he's years later under investigation for a possible breach, to say, actually, this is unenforceable against me. That's where I think we run into problems. We haven't touched at all on ripeness. I'm very happy to talk about this for as long as the court is interested, but I did want to at least briefly touch on ripeness, because it is a tremendous departure from normal orderly judicial review for a court to consider even a constitutional argument, even a threshold argument, while the investigative body here, the commission, is still ascertaining the relevant facts, deciding whether a breach even occurred.
Statute, and as part of that protective order, piece of evidence that they used in their investigation. However, you represented that the sole basis of this investigation is protective order, in which case it does potentially affect. Because there's a decision that the agency has made that this order is the basis for a sanctions proceeding. Maybe that is different from ordinary type of investigation where we would defer to an agency's prosecutorial discretion, consider other factors, waiting for them to actually take steps.
Yeah, so I think the commission is still in the process of even ascertaining the relevant facts. For example, Mr. Sidak has raised certain legal arguments to the commission about why he thinks the conduct that he's already admitted to was in fact allowed under the protective order. And I think we would normally allow, under bedrock principles of finality and ripeness, to let the commission go through that process. And I want to analogize this case to the National Treasury Employees Union case we discuss in our brief. It's a canonical ripeness case. And that case involved the constitutionality of the line item veto. Somebody wanted to bring a challenge to that. It's a pure question of law. We're not saying that it required further factual development. It was a constitutional question. And yet, what this court recognized is there's a prudential aspect to ripeness that sometimes it is more appropriate out of separation of powers concerns to let the administrative agency complete its process first, and that sometimes if you don't decide a case prematurely on the front end, you may never need to decide it. And that certainly describes this case. The commission hasn't.
Or the canonical statement. You could have cited that. You could have cited that. This proposition. Prudential ripeness involves fitness of question.
Sure, but
here's what also is your best case is standard oil, which is about finality under the APA. The case both sides most discuss is Axum, which is a case about when 1331 is impliedly repealed.
Yeah.
There's a lot of overlap in those doctrines, and you could toss in exhaustion if you want to that mix. But you're longer on finality in 1331 cases than you are on prudential ripeness. And if you compartmentalize a little bit and just think about prudential ripeness, the court has said it's a sort of disreputable doctrine, and we don't like prudence doctrines, and we're not going to extend it, and we may reconsider it. And we've said when there's a purely legal question at issue, we don't worry too much about prong 2 of added labs. So you're trying to import finality in 1331 cases into a prudential ripeness.
So I don't think I'm the one doing I absolutely take your point, Your Honor, and you're right that we do discuss some of those cases interchangeably. But part of the reason we do that is because this court has done the same thing. And in particular, one of the cases we do cite is that Tycor case where one of the three-way split. And if you look at footnote 7 of Judge Williams' opinion in that case, it was about 87. It's a little long in tooth. I understand. But if you look at that case, footnote 7 of Judge Williams' opinion, that it cites to a 1984 decision of this case called Public Citizen Health, where the court basically said the finality and the prong 1 of ripeness, two components converge and can basically be treated interchangeably. I would add that, of course, FTC versus Standard Oil, the first Abbott Longs, the fitness for judicial review. Fitness for
question purely legal, or is it factual and mixed?
I don't agree with, I think National Treasury Employees Union says there's more to fitness than just, is it purely legal? Whether or not, it's not just collateralness, it's, is there an opportunity for this case to go away, essentially? Can this be resolved by the other branches before the judiciary gets involved? The statement, and I'm paraphrasing here, but I think pretty closely, the often unstated, that the prong 1 incorporates the often unstated but true proposition that if we do not decide this case now, we may never need to decide it. And that's true even for pure questions of law, like the constitutionality of the line item veto. And of course, FTC versus Standard Oil, which we discuss at length, itself discusses Abbott Labs with quite heavily. So I do think these doctrines can't be put, while you're certainly right that they are separate lines of cases, there's a fair amount of overlap there. The other thing I'd point out is I don't understand Mr. Sidak to be taking issue with the fact that if he were arguing to this court, for example, those same legal defenses he's asserted to the commission, that, for example, the protective order scope doesn't reach the transcripts, it only reaches the primary documents, that this suit would be unripe. And the reason for that,
Mix and match point. I don't mean that.
Yeah.
Pejorative.
Oh, no.
But, I mean, that seems to prove too much. So if you take the, if prong 1 of prudential ripeness, it includes will the issue go away, and you mix and match with 1331, you get, Axon would have been right.
Right, and I agree, you can only take it so far.
Even for the defendant who is before the unconstitutionally appointed or insulated adjudicator, that is a more acute problem than.
So I think the reason that's not true, and this is crucial in Axon, is Axon said there was a particular here and now injury. It's not, will this case go away? Will the SEC or the FTC ultimately decide to sanction Axon or to sanction Mr. Cochran? But rather, the here and now injury was and this is, I'm quoting from page 192 of Axon, and this is the key element of that decision, being held before a, quote, unconstitutionally structured decision maker. And that is the distinguishing feature of Axon. It's the basis on which the court said, this isn't at all inconsistent with Standard Oil. We have no renewed enthusiasm for interlocutory review, but this is a special case. There's an exception when you're being subjected to an unconstitutionally structured decision maker. And I want to emphasize that Mr. Sidak has not challenged the jurisdiction or the constitutional structure of the ITC itself. And in fact, at oral argument in district court, you can see this at JA 142, he expressly said he wasn't challenging jurisdiction.
That is the best of Axon. There's another major strand on improving, which is not challenging some specific action taken in the proceeding, challenging the proceedings.
I think that reading would be far too broad, because if you think of FTC versus Standard Oil, for example, the allegation there was that the proceeding was improperly commenced because the requisite statutory threshold for starting it, whether the commission had reason to believe that there was a violation, was not met. Now imagine that Standard Oil's lawyers had just tacked on a due process claim and said that is evidence of an absence of due process, or a First Amendment retaliation claim, and said that is evident because they are proceeding on such patently insufficient evidence in starting this. They're bowing to political pressure. This is clearly retaliation for our public opposition to the administration. I don't think FTC versus Standard Oil comes out any differently post-Axon. So first of all, well, I said that hand in hand with his consent in November of 2017. And you'll forgive me, that's very important to me to emphasize. But what makes this different is the decision maker unconstitutional? There will be lots of cases. For example, if somebody wanted to bring a constitutional challenge to the FTC Act and say there was some defect in it, I think even post-Axon, and that's sort of analogous to the Elgin case, right? In Elgin, somebody was facing potential repercussions based on the draft, failure to register for the draft. There was a threshold constitutional equal protection challenge to that statute, that it discriminated against men. And there was no question that was the kind of situation where it was a pure legal question. It was the kind of thing, it was a facial challenge. And yet in Elgin, the Supreme Court still said you have to go through the administrative scheme. Now, again, that's a Thunder Basin case, and I am mindful of your point earlier, Judge Katsas, that I don't want to conflate doctrines too much. But the mere fact that somebody is saying the basis for the proceeding suffers from some inherent constitutional flaw, I think proves far too much.
So free enterprise recognize there would be, even for something that
Absolutely, yeah. So you can get a declaratory judgment as opposed to an injunction. Absolutely. So even before we get to whether they're right. So for the third argument, the third argument we've made in our brief is the district court committed legal error in failing even to consider the public interest. And in particular, the fact that this is an order that was designed not only to protect the commission, but also to protect the confidential business information of Apple and Intel and third parties who responded to discovery requests over the course of that proceeding. And under this court's recent decision in Zuckerman, for example, even if you think he was entitled to prevail on the merits, and of course we think he's not, but even if you get past that, deciding that he's entitled to prevail on the merits doesn't answer the separate inquiry of whether or not he's entitled to a remedy, an injunctive remedy. And a failure to even consider the public interest is just per se error.
They have the burden. They file what was then a PI motion that they argue all for.
Right.
If I have the chronology right, then gets converted into some judgment and summary judgment of responding to that.
Yep.
And we say, to the extent we're even still talking about deny equitable relief because they're unlikely to succeed on the merits and there's no irreparable injury. So you only controvert factors 1 and 2.
So
factors 3 and 4 are not subject matter jurisdiction. So if you haven't raised any issue,
well, I actually do want to push back on that a little bit, but there are a couple points I want to make here. So one point I want to make is I'm very glad you noted the chronology here. the parties agreed to convert the PI, and at that point, both parties just briefed this as cross motions for summary judgment, and neither side was really engaging with the equitable factors. The second thing I want to emphasize is that though we certainly didn't brief, well, it's
gets converted into a motion for a permanent injunction.
Well, motion for summary judgment was the focus. But I want to emphasize that the equitable considerations that we're pointing to in this court were absolutely before the district court. Now, I don't want to mislead the court. We did not frame this in terms of the equitable analysis. We were making these points in the context of other arguments. But if you go to JA 123, which is our district court brief, and then JA 183, the oral argument before the district court, we were talking about the same sorts of equitable considerations that our brief in this court talks about. The other thing I want to emphasize is Your Honor says, well, it's not jurisdictional. And I think that's right, but with a caveat, which is baked into the preliminary injunction or the permanent injunction analysis is a recognition that sometimes an injunction is going to impact not just the two parties before the court, but the public at large. And I think that's particularly true when a court is considering basically declaring void and unenforceable an order, the primary purpose of which was to protect non-parties to the proceeding. And when the court enters an injunction without even accounting for that fact, and without even referencing the public interest, I think that is the kind of error this court can and should address. I think this court often, if for an abuse, I think often in the context of an abuse of discretion standard, the court will sometimes say the lower court committed an error of law in failing to account for something. We send it back so that the court can apply its discretion in the first instance. I don't think that's remarkable. The other thing I want to emphasize here is there are intermediate steps you could take. For example, you could say maybe Mr. Sidak shouldn't be sanctioned, shouldn't be subject to some penalty on the basis of his conduct, but the commission can and should be able to at least ascertain the relevant facts and make sure he at least destroy, to the extent he still has any Apple or Intel or other information, that there's a balance that needs to be struck here to make sure he doesn't continue to retain information that potentially could leak, even if he's not planning on selling it or posting it on the internet. Now that he has the protection of this injunction, as long as it's on his computer, there's a risk of leak. And you could certainly imagine an equitable analysis here that takes account of Apple and Intel's interests and not, though I do want to emphasize the commission's interests here are substantial as well. People rely on the commission to conduct the kinds of adjudications that require consideration of very sensitive information. Congress recognized that, and we don't want that undermined.
Commission had a better answer, or why has it not just issued a new tech? And again, their only answer seems to be, we think they don't have to.
Well, there are two answers, Your Honor. So one is, of course, because there's already a well-established principle that protects commission orders from concluded proceedings, which is the finality. I understand. The second reason is because it's not like that would resolve everything. Mr. Sidak at times says there was an easy fix here. But then if you look at page 36 of his brief, and particularly footnote 2, he actually... So I don't think we could have, if we had just purported to reopen 1,000 long concluded investigations, issue a blanket ratification, and then try to enforce that without getting new signatures from everybody. We may well have that power to do that. And frankly, depending on how this case comes out, maybe we'll have to try. But I think if you read Mr. Sidak's brief, and particularly page 36, I think it would be foolish to assume that that would have just resolved the question, wouldn't have opened up new litigation.
Sanction in for what has been passed, but to the extent all of these equitable considerations go toward whether to issue an injunction or not, it seems like they could solve the IDC's problem.
No, the footnote I'm referring to actually questions whether whether ratifications are even effective. Thank you, Your Honors.
Morning. May it please the court. We're here today because to this day, 6 years after Lucia, the ITC still hasn't fixed its Lucia problem. The agency has never done anything to address orders entered by ALJs whose appointments were unconstitutional under Lucia. Instead of fixing the problem, the agency is doubling down and instead insisting that this court should allow it to enforce an order that it concedes is unconstitutional. As the district court recognized, that turns the law upside down and makes this an easy case. An agency has no right to enforce an unconstitutional order. That's basically the affirmative part of my case, which is an easy case. The agency tries to avoid that by saying, oh no, you're too early and you're too late. And the agency is wrong on both scores. I'm happy to address the too early arguments or the too late arguments or whatever the court is interested in my addressing.
You are focusing on Lucia, which was the ALJ presiding in the dispute between Apple. This is a separate proceeding for a lawfully structured.
Correct, which as Judge Rao.
The injury of being put into a proceeding whose adjudicator is either unlawfully appointed or unlawfully insulated from presidential control. We don't have that.
Right, but as Judge Rao pointed out, the sole basis, or there's an ask, and the my friend conceded, the sole basis for this new proceeding, the proceeding directed against Sidak, is alleged violations of the protective order entered by that ALJ. There's no other basis. And just to clarify, the injunction in this case does not stop the agency from doing anything beyond the four corners of the protective order. The injunction says defendants are hereby enjoined, and this is a JA 229, from using the protective order from the 337 proceeding investigation as a basis for investigating and or sanctioning plaintiff. So again, the proceeding that we have now is a proceeding aimed solely at enforcing an unconstitutional protective order. It's not.
But your merits theory is just a little bit different, right? Your merits theory is that this proceeding before a lawfully structured tribunal has some unconstitutional.
100%, because it is a
different.
No, fair enough, Your Honor. In other words, yes, we concede that this is not an adjudication before an improperly appointed adjudicator. It is a proceeding aimed solely at enforcing an order entered by a concededly improperly appointed adjudicator. There's no other, as the questioning with Judge Rao made clear, there's no other, there's three, no assertion that there's multiple grounds. The only basis for this proceeding and the only subject of the injunction is the use of the protective order. The agency is correct that is distinguishable from Axon and other cases in that sense, but that's really a distinction without a difference in the sense that it is a, I'm sorry, Your Honor.
Well, here's what I'm thinking about. I'm going to do the mix and match again, which is the general rule is standard order. You're a defendant in an administrative enforcement action don't like what's happening.
Sure.
You're claiming legal error, you're claiming even constitutional error, you're saying, look, legal fees are on and up, I can't sleep at night. The general answer is that's part of the ordinary duty of citizenship, and when the case is over, you can make whatever arguments you
Correct. Again,
want. That's the general rule.
that is the general rule, and we do not argue.
Axon is the exception, at least when you are thrown before an adjudicator unconstitutionally appointed or.
That's the question. And said Axon itself said, is this case more like free enterprise clause or more like Elgin? And we submit that this.
Your case, more like Axon or more like.
100% more like Axon, because we're not seeking anything to do with the outcome of the agency proceeding. We're challenging the fact of the agency proceeding. It's the here and now injury of being subjected to the enforcement of an unconstitutional order, which is a structural problem. This case is within.
So if we're just drilling down on individual cases and treating Axon as extendable to prudential rights, it comes down to whether the test is unconstitutional. The illegitimate proceeding or illegitimate proceeding led by illegitimate decision.
Illegitimate proceeding, again, that's the language of Axon, but it's a structural constitutional problem that is completely divorced from the merits. Some of the decisions they're talking about, like they had a constitutional question, which is, well, it's a due process problem if there's no factual basis. And Your Honor, Judge Rao, you were on a panel in the Loma Linda case last year that raised some questions about how would this apply in the context of a Leadham versus Kine Religion Act case. There are some tricky Axon-related issues that are floating around in your radar screen as the DC Circuit. But this case, where the claim is the structural constitutional claim, they are here and now. It's this Mr. Sidak, my client, his constitutional section 1331 claim is the exact same claim. It is a claim that my rights under the appointments clause, my structural constitutional rights, which have nothing to do, the merits could be about widgets. We have nothing to do with the way that process turns out. It is, I have a right not to be hauled in to this improper proceeding. Again, improper why? It's improper. It has nothing to do with the merits. In some sense, even their Standard Oil hypo had to do with the merits. If there's no, it's a due process claim. If it's that, Leadham versus Kine, it's a little more meritsy. This claim is exactly the same. I'm sorry. Correct. In other words, I think well, at the end of the hypothetical, what my friend just said is, well, in FTC, they could say, well, you know, the statute, the organic statute doesn't give you that power, or there might even be a constitutional problem with the organic statute. I mean, those are much more closely aligned with the merits. I think this court may find, and the courts generally may have some very interesting work to do on Axon and how far that extends. But this case, which is it's literally an appointments clause challenge. %100% different. And in fact, the injunction doesn't prohibit that. The injunction only says, again, JA 229, they're enjoined from using the protective order. Correct. The here and now injury is not the investigation per se. It's the use of an order entered by an improperly appointed ALJ. Okay, so on that, what they are really making is a Johnson versus Zerbst waiver argument. The agreement, let's look at that agreement. What it literally says, I have it here in front of me, it's JA 48. It says, I agree to be bound by the terms of the protective order. Okay, like we all agree to lots of things. That is not an agreement to that the judge who entered the order or the ALJ was constitutionally appointed. I mean, the notion that if Mr. Sidak didn't use the appointments clause as a sword to immediately attack the ALJ's appointment when he's an expert witness, all he did is agree to abide by the terms of the protector. He didn't agree to waive any right. Again, the Johnson versus Zerp standard for waiver of a constitutional right is a knowing waiver. Where in here does it say, I agree to waive any objection later? I mean, he's agreeing to abide by that. That assumes that it's valid. He's not agreeing. He's not giving up anything to use it as a shield in a subsequent enforcement proceeding. Well, you could, and that is very much the way the government is trying to push it, but their enforcement proceeding is not a breach of contract proceeding. It's a breach of protective order proceeding. I don't know that they would have the statutory right in an administrative proceeding to do a breach of contract. That goes into Crowell versus Benson and what the administrative authority could do. I mean, maybe there could be a contract. I mean, again, this is just not a breach of contract claim. But we are not arguing here. I want to be very, very clear on this, that the only dispute here is about their attempt to give effect to this protective order. And what's kind of weird here, frankly, is that they're saying it's too early. Their argument is that they should be allowed to proceed with an investigation, with a proceeding, possibly to impose sanctions for a protective order that they've conceded in this proceeding is unconstitutional. They've not defended the merits of this. So this is a particularly weird situation. I think Judge Katsas, you asked a question to my friend about this. Like, what on earth are you all doing trying to proceed with this proceeding to enforce something that you've conceded is unconstitutional? The only answer I can think, well, I'm sorry, Your Honor.
That aspect is very stark.
It started, I think it's.
I wonder if the question of is this more like Standard Oil or is this more like Axon? Need a little bit more categorical answer than this is startling because the appointments clause question is so clearly undisputed, and the purpose of the enforcement action is so clearly and exclusively to enforce the unconstitutional.
Yes, so you
all
just.
that together and say, wow.
Well, to what end? I mean, so I mean,
Why shouldn't we think of this as the classic case we're assessing is the defendant is in an enforcement proceeding or a lawfully constituted tribunal and is arguing that the object of the proceeding is unconstitutional.
because.
Sounds much less shocking.
I get that, but again, it's somewhat shocking where they have conceded that the thing they want to enforce is invalid. Well, no, but again, I think you, Your Honor, yourself had pointed out that Axon, they brought out one snippet of Axon, which said something about the adjudicator. But I think as Your Honor yourself pointed out, there's lots of other places in Axon, not even to mention Justice Gorsuch's concurrence, where he is talking about, we have 1331. I mean, a lot of these doctrines, Thunder Basin, they are doctrines of administrative regularity, and that's fine. But again, where you have somebody who has a structural violation, particularly here where it's a conceded structural violation that lies at the root of the only thing the agency is trying to enforce. Again, I think this is probably the best answer to this, which is to say, I'm sorry, Your Honor.
Whether you can come into district court now depends on how obviously unlawful agency.
And fair enough. Look, that is on right. That is almost that's a very difficult standard. Again, I think where it is a structural constitutional argument based on the appointments clause at least, okay? I mean, this literally is the same structural constitutional claim that Axon said imposed a here and now injury. So the question that they're presenting, that they are positing that there is a dispositive difference between saying that your appointments clause is to the challenge is directed only at the adjudicator of that challenge, or versus something that is at the underlying order that is the sole basis for the entire new proceeding. Whereas here, the only basis for this proceeding is to enforce an order that is concededly entered in violation of the appointments clause. Again, it seems to me that easily falls within both the spirit and the letter of Axon as saying, what on earth would you allow this to go? There are many different, I'm sorry, all right.
Those the order were entered in violation of the person.
Again, well, some First Amendment claims may be more bound up in the merits. This is actually very similar to the Loma Linda case where Judge Rao was on the panel, where there was a Leadham versus Kine argument that somebody said, I have a First Amendment right not to be subjected to this. A merits panel said, the majority over Judge Rao's dissent said that is really just a statutory argument that is intertwined with the facts. Again, the FTC versus Standard Oil argument hypothetical that my friend presented to you, where he said, well, there's zero factual basis for the proceeding, so that's a due process clause. I mean, I think you can draw distinctions where those things are in some way tied up with the merits. This appointments clause issue is a structural constitutional issue that has zero to do with the merits, as we know, because the court in Axon has already said that. Now, again, they were saying that in the context of the adjudicators before it, but it's the same principle that where the claim has nothing to do with anything to do that's going on in this administrative proceeding and nothing that happens in the adjudicative proceeding could in any way, they've never suggested any way in which that could shed any light on this, that whether or not he violated protective order has any bearing whatsoever in any conceivable way. The only argument they've made is to say, well, we may wind up deciding in his favor. That actually, as Axon and Carr versus Saul makes clear, cuts in our favor because the here and now, apparently what they're trying to do or what they're saying they have a right to do is continue to impose all these costs and uncertainty on Mr. Sidak and then say, oh, guess what? We've decided not to impose a sanction. They almost have to do that because they've conceded that the only order on which they're basing the proceeding is unconstitutional. So any sanction that they would impose would have its death warrant on its face if he decided to go to court. What they want to do is really an abuse of the administrative process. I mean, I think this case presents to this court probably the starkest example of what you will see is just a naked abuse. I mean, this wolf is coming as a wolf. These people are not coming here in order to validate some otherwise legitimate process. The only basis, again, I think this goes. Again, if it were some other basis, right?
Merits question is just in terms of protective order. You say this is retaliatory for something he did.
Then it tends
the
right.
whole proceeding is unconstitutional because it has.
I think that at least that is one of the hard Axon questions. I'd say our case is an easy Axon question. Right? I mean, when you start to get into those kinds of questions, it starts to raise. If they just say this is improperly motivated, I think that probably is a Standard Oil versus Exxon thing. Again, I don't deny that is the background rule. I think though, if you take the same approach that the Supreme Court did in Axon, and I understand Axon is a Thunder Basin case, but it's the very same kinds of issues. Again, I think those kind of things where you have to even think of the merits,
Before there was ever even the proceeding after the Qualcomm, there was presumably some regulation that said you can't violate an ITC.
Sure, that's it. There's a statute that, and there's regulations, yeah.
Then comes Qualcomm proceeding, unconstitutionally appointed ALJ issues technical order violates, arguably, possibly, allegedly violates the unconstitutionally structured ALJ's technical order. Then this proceeding, if you think of it like that, proceeding is for his violation. First of all, this proceeding is by a perfectly legitimate constitutionally appointed decision maker.
Now, yes.
And it's for his violation of a statute and regulation that are completely fine. And the protective order is really just a piece of evidence showing that he violated a perfectly fine regulation.
Your Honor, if that were the case, that this would be a different proceeding. Again, I think that was Judge Rao's first question to my friend. Is this a case about a violation of the protective order or some other statutory or regulatory?
Is it violating the protective order, or is it for violating basically a kind of quasi-contract he agreed to abide by? My scenario is kind of, I guess, third. Is this proceeding for the violation of a regulation that says there's what you? Okay, well then I'm sorry, I misunderstood the question.
No, but clearly it is, if you look at the May 25th letter, I think it is clearly the protective. Just look at the first line. Dear Mr. Sidak, this letter concerns a possible breach of the administrative order, APO, issued in blah, blah, blah. That's JA 49. And again, Your Honor, we know if it were something broader, as Your Honor's question is asking, that wouldn't be enjoined. The only thing that is enjoined by the injunction, it's a very narrow injunction that the district court entered in this case.
If there weren't the original regulations, you can't violate it, then would this proceeding happen?
If you could separate that from the protective order, I mean, I guess that raises some very tricky issues. Are you bringing I think that order seems to me to be entirely contingent on the validity of the protective order. So I don't think that regulation alone, thou shalt not violate a protective order, is really a statutory or regulatory basis independent of the protective order. If I'm understanding your hypothetical correctly, I think that would be covered by the injunction. So I don't think they can just be cute and say like, oh, we're no longer the protective order, we're now the rule. But as long as it is about the protective order, again, entered by an unconstitutionally appointed ALJ. And again, you asked my opponents this question, my friends this question. Why don't you guys fix this? We wouldn't be here if they had fixed this. And that goes back to the equities of this. That's what's so weird, that we're here in the DC circuit today using all of our time when this agency could just have fixed it, as other agencies did.
District court order is plan free now to just go on the market and sell these secrets to anyone who wants.
Well, he has made clear in his affidavit, which again, that's a whole other part of this case that isn't here, about the coercion of that affidavit, that he destroyed the parts of the case file that were beyond the confidential, about the hearing transcript. Again, let's go back to the genesis of this case. This is about his use of pin sites to a confidential hearing transcript where he was filing FOIA requests. They turn and says, aha, gotcha. This means you're violating the protective order, right? They have never alleged that he violated, that he actually disclosed anything. Correct. And again, you're going to the equities of, well, anybody may remember that there's no obligation to erase your memory. Well, again, that's why I think they should try to fix this immediately, if not yesterday. No, I mean, no, right. I guess I don't, yeah. I mean, I guess as we are here together today, right now, there is no legally valid thing stopping people. Our only point is to say, when they bring up this parade of horribles, they bring up Apple, they bring up all these other companies, right? They can fix that. You don't need, under the statute and regulatory authority they have, they could fix it today by entering, some kind of an order saying anybody who received confidential information under a protective order entered by an unconstitutionally appointed judge is prohibited from doing that. Until they fix that, though, they can't go around and say, like, oh, no, we have to have the obligation to enforce an unconstitutional order.
Too late.
With respect to Sidak, it's too late. Yeah, they can't. Well, no, I'm sorry. I thought I was going back to Judge Walker's hypothetical. He was asking about things that Mr. Sidak might do in the future. If today they entered an order, they could certainly stop Mr. Sidak. We don't say Mr. Sidak gets forever and for all time carte blanche to do whatever he wants. At least until there's a protective order, Mr. Sidak and anybody else whose conduct is governed by a pre-2018 protective order. Why do I think they have an issue? Well, they have. Oh, Your Honor, that's a long answer about this agency. This is an agency that even after Lucia, if you look at the Federal Register notice in September of 2018, which is in the record, they continued to insist after Lucia that they never had a Lucia problem because the other commissioners had a veto on the chairman's unilateral thing. Even though 10 years ago in free enterprise, this court said multi-member enterprises, the head of the agencies, the head of the department is the whole agency. So this is an agency where accountability is an extremely foreign concept. I mean, this dispute should never have arrived in federal court. It is a shocking manifestation of where we are in administrative law in the year 2024, that we are here debating this and that we haven't, the federal government is coming here and saying, yes, please give us carte blanche, please overturn this injunction that stops the agency from using a protective order that the agency has conceded is unconstitutional. So again, Your Honor, it blows my mind that they have not tried to fix it. I think they can get away with it. And so why not? And, I certainly hope this court agrees with the arguments in our brief and with the district court's opinion, which very carefully and again underscores the narrowness. The district court said, look, if this were a parties, different story. Parties have their rights and obligations at issue. They have certain obligations. We have never in this country had a world where anybody who has any kind of obligation entered into confidentiality, decorum in court. If somebody in the court starts disrupting this court, right, we all have certain obligations. That doesn't mean that just you have a certain implicit or explicit obligation that you're waiving your right thereafter as a non-party. If there ever is an enforcement proceeding against you to bring whatever defenses you might want to bring. Again, that has never been the law in this case. And so I think in this country, and I think their attempts to enforce this order take administrative law well beyond where it has ever been.
District court has this rather dramatic citation where we right. There is also, and actually, so why shouldn't we at least send this back for the district court to weigh factors 3 and 4 in light of that?
2 reasons, Your Honor. Well, 2 reasons, Your Honor. This remedy provision, and I invite you to look at the briefs below on this, and I urge you to do that. And I know you have, because that came up, right? They have an obligation, right? Right. They never challenged 3 and 4, right? Everybody agreed. Well, again, he didn't need. But that affirmative misstatement, Your Honor, if that didn't exist, that's not critical to his reasoning. I think his point is the only remedy that is, when you have a more traditional way that one of these appointments clause challenges comes up, like in Lucia, it's reassignment for adjudication before a properly appointed decision maker. when the agency, again, it's almost crazy to imagine this is what is happening, but this is the nightmare that Mr. Sidak is living in. They have decided to actually try to enforce a conceitedly unconstitutional order, right? And so the only remedy to stop that is to say, stop that, right? You can't go and reassign anything to somebody else, right? They never disputed that point. That was kind of the clear thing. And with respect to they never said there was some other adequate remedy at law. They never suggested that. With respect to the public interest factors, the district court, if you look at JA 227, he does say if any so in other words, let's just go to the procedural point. This is bedrock law that you, as the DC Circuit, are not a self-directed board of inquiry looking for possible mistakes that were never. A lawsuit has a certain proceeding in the adversary system, and the government is a very worthy adversary. If they thought that the court could not enter an injunction because of the public interest considerations, it was up to them to tell the district court, you cannot enter this because of these public interest considerations. They said boo about that. Now to come up on appeal to the DC Circuit and say, please vacate that because we've now come up with these other arguments. In any event, so that's the procedural argument, that there has never been in the history of American law, as far as I'm aware, some argument that the injunctive factors are impervious to the normal rules of waiver and forfeiture. But even on the merits, the district court actually does say on JA 227, if any broader reliance interests are affected in this case, the commission is to blame. Unlike other agencies, the commission took insufficient curative action. That is a complete answer to their argument about the alleged equities here, the apples of the world who are going to be suffering, right? That they can fix it. The answer is not yes, go ahead and continue. We're going to withhold an injunction. Go ahead and continue to enforce the conceitedly unconstitutional order. If you look at, we made this point in our brief. It's very interesting. They don't ever say this is impossible to fix. There's one sentence on page 30 of their reply brief where they say, well, it's complicated. Okay, well, many things are complicated in life, but that doesn't mean that means that they can basically be allowed to enforce an or a conceitedly unconstitutional. There's no further questions. Thank you.
Thank you, Your Honors. You've already been very generous with your time, so I just want to make a few quick points. First, I want to emphasize that I heard Mr. Landau repeatedly refer to a structural constitutional error in dealing with the Axon type issue here. I just want to be clear that the district court here expressly said the opposite at JA 213. This is not the kind of structural challenge that involves being hailed in front of an unconstitutionally structured decision maker, which inflicts a here and now injury regardless of the outcome. His alleged injury here is much more limited. It is tied to the potential outcome of the proceeding, not the mere fact of having to appear before the ITC, who he concedes at JA 142 has jurisdiction. Second, he asks, why are we even doing this? Why is the ITC, this Xavier-like entity, going out there? And I think there's two answers to that I want to emphasize. The first is that it's important to the commission at least to ascertain the facts here, which it has not been allowed to do. He says all they had were some pin sites in a FOIA request. That's where it started. And then when we asked, it turned out until recently, he'd kept his entire case file. That's what came out in the affidavits. So the fact that when there was an initial thread that the commission started pulling on, I think is certainly relevant. If he's been disclosing information, we don't know that yet. He says he hasn't, but the commission hasn't had a chance to drill in. Obviously, that would implicate a far broader range of concerns. The other aspect I want to emphasize here is I heard him repeatedly say we concede it's invalid. And I think that the protective order is invalid. And I think that that's not a great encapsulation of our position. What we haven't contested is that the ALJ wasn't properly appointed when it was issued. But under traditional principles of finality, the commission does not believe that it is enforcing an unconstitutional or unenforceable order. Before Lucia came down, literally millions of decisions were issued by ALJs in dozens of agencies. And for the most part, there were some Lucia claims preserved, and the government had to redo a lot of cases on the basis of Lucia. But that number is dwarfed by the number that everybody has just assumed continue to have vitality. And yes, the government routinely continues to proceed on the basis of the validity of ALJ decisions that were issued pre-2010. The last thing I just wanted to do was Judge Walker. That's the timeliness argument, not the consent argument. And which goes into the collateral attack in the Ryder point. And the last thing I just want to do, Judge Walker, you were asking about the regulatory scheme that underlies the protective order and what's being enforced here. I would refer the court to 19 CFR 210.25, which provides exactly as Your Honor suggested, the relevant set of regulations.
Very first question for you is because I may not have understood your answer to Judge Rao's question. So I get that you're not just proceeding because he failed to do something he couldn't do. Something, he just like absent a protective order. He told the ICC, I'll go after the basically.
Yeah.
And he didn't. That's not your. But is your theory, not theory, but is the way this proceeding works as follows? Years ago, there was a statute authorizing a regulation. The regulation is not challenged. The regulation says you cannot violate an IPC protective order. And you are bringing essentially an enforcement proceeding against him for violating valid regulation that says you cannot violate it.
So I think they go hand in hand. Part of the problem, this proceeded on the basis of letters to this point. So it was started with a letter. It's captioned, possible breach of the protective order. But the reason the commission, the regulatory authority underlying that, so to that extent, when I answered Judge Rao, what I was certainly saying that we are proceeding on the basis of the protective order, not a contract theory, not just a bare violation of statute, independent of the protective order. But the protective order very much goes hand in hand with, and the reason we have authority to enforce it is because of this underlying regulation. So we can't do that, I want to be clear. So honestly, and the court should be aware of this, these are laid out in 210.134.c. Mostly it's like letters of reprimand. Could be a private reprimand, could be a public reprimand. If it was more, they escalate. The most extreme things we can do are bar you from practicing before the commission and a potential referral to like your state bar authority. Yes, absolutely.
Not this individual protective order.
That's correct.
Thank you.
Thank you, Your Honor.
Counsel, for vigorous and excellent arguments. The case is submitted.
This honorable court now stands adjourned until Thursday night at 9:30 a.m.